Good morning and welcome to our conference, International Investment Arbitration in Latin America, Progress or Inertia. My name is Álvaro Santos. I'm a professor at Georgetown Law and faculty director of Carola, our Center for the Advancement of the Rule of Law in the Americas. We have a wonderful lineup of speakers today, and I'm sure you will enjoy the lively discussions. I want to take a moment to thank Dr. Pascal Akawi from Credimi and Álvaro Galindo, the Dean of University de las Americas Law School, who first approached us with the original idea for the event and were instrumental in bringing it together. I also want to thank Lelia Muni, Carola's executive director, and Bhavya Singha, a student from our Georgetown Journal of International Law. This event would not have been possible without all of you. So in these remarks, I want to do three things. First, I want to say why Latin America can be a good lens through which to analyze the status of international investment arbitration. Then I want to introduce the themes of the panel. And finally, I want to propose three categories to think about changes in the international investment law region. So let me move to the first of these topics, Latin America as a good lens. And I want to focus here on two periods. The first one, we can go back to the late 19th century when jurists from the region were developing international doctrines that sought to reinforce the sovereignty of the fledgling nation states. One such doctrine was developed by Argentinian jurist Carlos Calvo, and substantially this doctrine asserted that the applicable law for an investment was the host country was the domestic law of the host country. Procedurally, disputes had to be solved in the national courts, and investors would forfeit their investments if they invoked their home country's diplomatic protection to resolve a dispute. Many states in Latin America incorporated this doctrine in their constitutions, and it spread beyond Latin America to other developing countries. So we had this very sovereignty assertive and nationalistic doctrine that dominated a big part of the 20th century in the region. A second period was with the advent of the Washington Consensus. Countries in the region moved away from those legal institutions and doctrines and signed a plethora of international investment agreements and trade agreements with investment chapters. In the 90s, the numbers of international investment agreements exploded as faith in this framework as a mechanism to attract investment spread around. So one consequence of these new commitments was a subsequent explosion of investor-state disputes in the following decades. So let me show you a few brief slides that we've put together at Carola. We've worked on two databases, one of international investment agreements in the region and another one of international disputes. And so here you can see in the first slide, next, please. Kylie, yes, thank you. So you can see the dates of signature of international investment agreements in Latin America. And then the treaties that are in force and treaties with ISDS. But you can see the explosion beginning in the 90s of these agreements and then slowly going down in the 2000s. Next, please. Next slide. Thank you. So as a consequence, you can also see in the 2000s an increase in the number of investment disputes in Latin America. So of a total of 942 investment disputes in the world, Latin America has a share of 258, so about 27%. Next, please. Here's a map of the countries and the disputes that they've been subject to. So you can see some of the countries that have been most affected: Argentina, Venezuela, Ecuador, Mexico. But many countries, most of them have had disputes already. Next. One result of this explosion in disputes is also that some states have decided to terminate their treaties. And this happened also in the 2000s, and it's ongoing. Next. Here you have a table showing you the countries, the treaties they have currently in force, but also the ones that have denounced those treaties. And there, Bolivia and Ecuador stand out as the countries that denounce most treaties in the region. Next. So here you have a breakup of the disputes. How many have been decided in favor of the state, how many in favor of the investor, but also the total claims, which add to 150 billion. And then if we see the next slide, of those claims, 29 billion has been the amount of the awards. So this is a considerable, so now we can finish the slides. Thank you, Kyle. So what you can see is also the important fiscal burden on states that the awards represent, but also the resources needed to manage the disputes and defend themselves. And also the preoccupation with the shrinking regulatory space as a result of this framework. So we think we're at a moment of flux, of reflection and reconsideration, taking stock of what has happened. A really important change is that while many of these concerns were previously advanced by developing countries, we're seeing a very powerful critique of the system by rich countries that have now themselves become capital importing countries. And you could see that, for instance, in the preoccupations and the result of the EU-Canada agreement, CETA, that created a permanent appellate body for investment disputes, the USMCA between the US, Canada, and Mexico that dramatically reduced the scope of investors' rights and only retained that for US and Mexico. And the discussions that we're seeing at multilateral, very important discussions that we're seeing on the possibility of reform of the system at UNCITRAL and ICSID. We're also seeing some countries that have denounced their treaties because they deem them harmful to their domestic policy objectives. So there are many issues for potential reform. Some are procedural, like the code of conduct for arbitrators, the possibility for counterclaims. Some are institutional, and some are substantive. So let me move now to the themes of the panels that we have for you today. We have 3 panels. The first one deals with the right to regulate. And here the question is, how is this right taking shape? What can we say about the way in which states have been constrained by the framework, and how can we imagine its expansion? So if we take seriously the idea of policy autonomy, how can the investment law regime embrace this core concern, and what will be the possible outcomes of that? What are the pros and cons? The second of these themes is legal obligations for investors. So this is our second panel. We started out the regime with rights for investors and obligations for states, and there's a pushback and a concern with the possibility of changing that, rebalancing the rights and obligations of states and investors. What would that look like? What kind of obligations would investors have? How would that affect the system? Can we move beyond oratory declarations and good wishes to think about how these rights could be, how these obligations could be implemented? So, these and other questions would be addressed by the second panel. And finally, the third panel is about dispute settlement, prevention and management. And so this is really an institutional take on how the system is operating, and also what can we see as potential changes within the system to improve the way it's working and the consequences for states, balancing again the desire to be a host state that is conducive to attracting foreign investment, but at the same time, one that puts at the foreground the interest of states in being able to pass regulatory objectives that are important to them. And so let me just say we have designed each panel in the form of a debate following a dialectical method. So one speaker will take a favorable position on the issue, another one will raise concerns and illuminate reasons for opposing change, and a third one will try to reconcile or synthesize these positions. And finally, we will close the conference with remarks by Professor Makan Benge, who will help us draw useful comparisons to the African experience and developments in that continent. So we expect very lively discussions, and we're very grateful to our speakers. I should say that speakers will be presenting these views, but often they don't represent either their own personal views or the views of the organizations that they work on. So they'll make this caveat themselves, but I just wanted to put it immediately here. And so finally, let me move to the three categories that I announced can be helpful for thinking about change in the international investment law regime. And this is part of a policy brief that we've worked on at Carola. The authors are two graduate students from Colombia, Nasli Duarte and Daniel Mejia, who did their LLM here while working with us at Carola. And this policy brief will be published soon. You will get a notice from us. You'll be able to find it alongside the two databases that I mentioned and the analytical graphics, some of which you just saw in the slides. And so what this policy brief proposes is three ways of thinking about change. First, redomestication, which is, well, let me just announce them. Redomestication, reconceptualization, and reform. So redomestication goes back to these earlier ideas of making national law the paramount law that governs investment, and making national courts the courts where disputes are resolved. So in some ways, it's an echo of the Calvo doctrine in modified ways. It's not exactly the same, but obviously that's in the background. And we have countries in the region that have delinked or denounced their agreements, like Bolivia, Ecuador, but also in other regions. South Africa, with its Protection of Investment Act, is an example that moves in that direction. Then we have reconceptualization, and this means staying engaged with the international investment regime, but radically rethinking it to include aspects of or other objectives, many of which were at the beginning of the investment regime's aspirations, like, for example, development or sustainable development and sustainable investment. And so there are several proposals about how to do this, including a framework convention on investment and sustainable development that our own Harrison Clinic at Georgetown and the Columbia Center for Sustainable Investment have put together. We were happy to support that initiative. But we also have international investment agreements that try to go in the direction of including obligations for investors, for example, the 2016 Morocco-Nigeria BIT, and other efforts, like, for example, Brazil's model for investment that doesn't have ISDA, but has a state-to-state dispute settlement system, and more importantly, an ombudsman and a strong emphasis on conciliation and amicable resolution of disputes. And finally, the third of these categories is reform, which basically talks about, deals with long-hanging fruits that could remedy some of the problems and abuses of the system. We're seeing a lot of discussion currently at UNCITRAL on this front, but we're also beginning to see an interest in many other more substantive issues. As I mentioned, this is part of the work that we're doing at Carola. I encourage you, as you hear the panelists in the three different panels, that you think about where would you situate these proposals for change? Are they an effort to redomesticate? Are they an attempt to reconceptualize? Or are they an effort to reform the system, perhaps in less transformative ways? With this, I want to thank you for joining us today and proceed now to introduce the chair of our first panel, Dr. Pascal Akawi, who is an associate member of CREDIMI, a research center on international markets and investment law affiliated to the University of Burgundy, France. Her PhD was on the renegotiation of the international contract and was published in 2011 by Bruylant. She regularly contributes to International Law Review with articles on international contracts and investment contracts and arbitration, including the right of the state to regulate and the protection of investors. She organizes webinars and gives lectures on these subjects. She has been guest lecturer at the ESSEC Business School, and she's a member of the ICC Institute of World Business Law and the ICC Commission on Arbitration and ADR. She's a member of several working groups, including the Working Group on International Contracts and the International Law Association. It's my pleasure to introduce Dr. Akawi and to thank her again for her incredible dynamism, her intellectual force, and for basically bringing us together today. Thank you very much.
Thank you, Alvaro, for this wonderful introduction and for kind words, and your introduction that puts into perspective the importance of this webinar and the presentations of the speakers that will follow. Panel one that I will moderate is entitled Right to State to Regulate. Is it an admission, evolution, or a revolution? As you mentioned, the right of the state to regulate is an expression of state sovereignty. It means that the state has the freedom to adopt a measure that it deems necessary for reasons of public interest. This idea behind this right is that the state protects the public interest and as such can and indeed must adopt measures in the name of that public interest. Latin America has been at the forefront in asserting the primacy of the state's right to adopt measures in the public interest. This generally unquestionable right is put to the test when this exercise has an impact on the foreign investor, whose protection is ensured by the emergence and development of international investment law designed for the promotion and the protection of investment and recognizes rights for the benefit of the investor and obligations for the state. The limitations on the state's right to regulate include the impossibility for the state to impose any new regulation on the foreign investor, notably through the insertion of the stabilization clause, the admission of the right to regulate in return for compensation through the qualification of expropriation on the basis of the link established with the depreciation of the value of the investor's property, whatever its value, or finally, the emergence of the concept of indirect expropriation. This investment law is going through a crisis, one of the components of which is the affirmation of the state's right to regulate. The question is whether we are witnessing a revolution or a simple evolution of this right to regulate, and if so, what is its scope? To answer this question, we have three very high quality speakers who have been asked to take position, not in their own names or the name of the law firm or institutions. So Nathalie Bernasconi-Osterweiler, who has been asked to support the right of state to regulate, is Executive Director of the International Institute on Sustainable Development. She also oversees IISD's function as the Secretariat of the Intergovernmental Forum on Mining, Minerals, Metals, and Sustainable Development, and the China Council for International Cooperation on Environment and Development. Nathalie has extensive legal policy and training experience in the areas of public and private international law, trade, investment, sustainable development, human rights, international environment law, and international dispute settlement. In Switzerland, Nathalie is admitted to the bar of Basel and worked for the Swiss Department of Justice in the section for international law. Jimena Herrera Bernal, whose position is to challenge this right of state to regulate, is a founding partner at Gaillard Boniface Michel via disputes. Prior to that, Jimena was a partner at Sherman & Sterling. Her experience comprises investment treaty arbitrations under bilateral and multilateral treaties, as well as commercial arbitrations in the oil and gas, power, infrastructure, etc., and arbitration under a variety of rules, including the ICC, ICSID, NCIA's, in situ rules. And she acts also as arbitrator, and she was part of the commission set up by the Colombian Ministry of Justice for the reform of the Colombian arbitration law, and a member of the task force for the revision of the IBA rules on the taking of evidence of 2021. Jimena is admitted to the bar in Colombia, in New York, and is a solicitor in England and Wales. I will introduce our third panelist who has problem to connect, who is Jose Ferris, and I hope that he could be able to join, whose position is to bring views closer together. He is a partner at Squire Patton Boggs and represents parties to commercial and investment arbitrations, sits regularly as arbitrator and teaches international arbitration at Sciences Po. A former Deputy Secretary General of the ICC International Court of Arbitration, Jose was also instrumental in revising and implementing the 2012 and 2017 ICC arbitration rules. He is Vice Chair of the ICC Commission on Arbitration and ADR, Co-Chair of the ICC Task Force on Corruption, and Vice President of the Latin American Arbitration Association, among other institutional roles. So normally the time allocated to each speaker is 10 minutes and followed by 25 minutes for Q&A. Without further ado, I give the floor to our first speaker, Mrs. Nathalie Bernasconi Osterwalder. Nathalie, the floor is yours.
Yeah, thank you very much, Pascal. And I would like to thank Credimi and Carola for inviting me to this discussion. I really think that your institutions have a very important role to play in advancing the debate on crucial topics relating to trade and investment law and policy. And I am very excited to be part of this debate today. So as we have heard from Pascal, the topic for this debate focuses on the right to regulate in the context of international investment law. And of course, we all know that the right to regulate in the public interest is a customary right of a sovereign state. And in fact, it's not only about the right to regulate, but as we also heard, about the duty to regulate in the public interest. I've worked on the intersection of international economic law and the right to regulate for many years now, but I was curious to see what would pop up if I just Googled the right to regulate. Almost all the hits in Google related to the right to regulate in the context of international investment law. Now, only recently I did discuss with some friends that when you Google a term, the proposed pages will be tailored to your specific device. So in this case, some search outcomes may have been influenced by the fact that I indeed work on international investment law and often search that term. But I don't really think that that's it, because when I went to the following pages, I came to the same result. I think that the issue of the right to regulate has become a pressing issue in the context of international investment law in a way it has never done in other areas of public international law. So let's look a little bit at the evolution of the right to regulate in international investment law. Early bilateral investment treaties that were concluded between maybe 1960 through 2000 and sometimes even beyond that, never mentioned the state's right to regulate explicitly. But that's probably not so different from other types of treaties, because actually the sovereign right of a state to regulate is indeed always the starting point and doesn't need to be spelled out in each treaty. Nevertheless, investment treaties started posing real threats on the right to regulate in the late 90s and the early 2000s. And this was when the first ISDS cases, investor state dispute settlement cases, were launched. That was the period. Before, we didn't know these kinds of treaty-based cases. The alarm bell really went off when Ethel versus Canada became public. This was one of the first cases brought under the North American Free Trade Agreement in 1998, and it hit like a bomb. In that case, Canada had banned the import of a gasoline additive, in short, MMT, for environmental reasons. There was concern that manganese, which is part of MMT, and I'm not going to spell out the chemical term because I will mess it up. So MMT, that the manganese, which is part of this MMT, has toxic properties that had not been fully assessed by science. And also there was a concern that MMT caused newly required equipment on car exhaust systems to malfunction, which would lead to increased air pollution. Now, the case was ultimately settled very much in favor of the investor. The law was retracted and never went into force, and the investor got 13 million. But this was nevertheless, even without a decision, the beginning of a sentiment that international investment treaties or chapters in free trade agreements could undermine a state's right to regulate. Subsequently, we started seeing tribunals, often composed of commercial lawyers, focused on the very narrow objectives of investment treaties, which, as we know, is to protect investors. And these tribunals often ignored other prerogatives of the state to protect other stakeholders and to protect the public. States were really taken by surprise. They had not foreseen any of these consequences. In Europe, where states had bilateral investment treaties but were mostly capital exporters, governments stayed largely oblivious with respect to investor-state dispute settlement and the negative impacts on the right to regulate. But in North America, things were different. While the United States and Canada had originally imagined using NAFTA Chapter 11 on investment against Mexico, the big surprise was that the mechanism was used against them. So it's not a surprise that the 2004 and later the 2012 US model bilateral investment treaty tried to more clearly protect policy space and the right to regulate. This was particularly clear in the new language regarding indirect expropriation. And similar approaches were taken in Canada and elsewhere. But these early changes to protect the right to regulate didn't really result in success. Challenges to environmental and other public policy measures continued to be challenged, or the measures continued to be challenged. And some of the focus shifted from expropriation to the fair and equitable treatment provisions, which were regularly very broadly interpreted by investment tribunals, particularly through the concept of legitimate expectations. States reacted in different ways to these developments, sometimes through new approaches to the fair and equitable treatment clause, as we know, for example, in the EU's listing approach, which the EU is using in its investment chapters in free trade agreements with Canada, Vietnam, and others. And we also have new fair and equitable treatment approaches in the Comprehensive and Progressive Agreement on Trans-Pacific Partnership, CPTPP, or TPP-11. And this agreement, in contrast to the EU's approach to fair and equitable treatment and listing what it means, this approach still focuses on fair and equitable treatment in relation to customary international law principles. Then still other treaties, they mention the right to regulate in preambles, or they have introduced exception clauses, maybe similar to those known in the trade context, for example, in Article 20 of the General Agreement on Tariffs and Trade, GATT. So all of these are really important developments, and some are arguably better than others, but frankly, they have been without much impact to date. And I am concerned that this will also be the case in the future. I think there are two main reasons for this. First, investors keep using old style agreements. So as long as a large stock of old treaties exists, these old style treaties will continue to be used. This is possible through treaty shopping, or in some cases by using MFN clauses and other vehicles. UNCTAD has documented this very clearly. And even if new approaches are integrated and claims are brought under those new treaties, we have indications from the North American experience that tribunals tend to ultimately do what they want on treaty application and interpretation, and often in contradiction to the intent of the treaty parties. So let me give you a short example. Pascal, do I still have a bit of time?
2 minutes left.
Okay, I want to just end with an example. In 2010, ISD organized a training in a country in Southeast Asia. Among other things, we discussed the fair and equitable treatment standard and what options governments have to protect policy space in that context. I remember exactly how my colleague was in process of presenting the NAFTA approach, in which the fair and equitable treatment, or the minimum standard of treatment, was tied to customary international law, in contrast to the broader FET standard typically included in older investment treaties. She was discussing the Glamis Gold case versus the United States, and how the customary international law interpretation safeguarded California's requirement to backfill a mine. As she was talking, another colleague and we were listening, but also looking at our screens, and we received the most recent IA Reporter, which maybe many of you know, report on the latest decisions that come out in investment law and policy. And this edition discussed a new decision interpreting NAFTA's FET or minimal standard of treatment clause. This was the Merrill and Ring versus Canada case. And that case, the tribunal pretty much ignored the approach championed by the US and Canada, as well as the previous Glamis Gold tribunal. The tribunal simply said that in the specific context of business, trade, and investment, the minimum standard of treatment included a guarantee of fair and equitable treatment, which was broader than the famous near standard case, which was the basis of the Glamis case I just mentioned. But it did not do a rigorous job on defining the evolution of customary international law and examining whether a new customary rule had emerged from a general practice accepted as law. Instead, the tribunal simply relied on previous investment cases and concluded that a new customary rule had emerged requiring that aliens be treated fairly and equitably in relation to business, trade, and investment. It found that no bad faith and malicious intention of the state was needed in order to breach the minimum standard of treatment or fair and equitable treatment standard. So in short, the Merrill Ring Tribunal simply ignored the will of the treaty parties and the public international law definition of customary international law. And my colleagues and I, yes?
Thank you, Nathalie. I need to stop you, unfortunately. Yes.
Let me just close by saying that I strongly advocate developing new language and treaties to protect the right to regulate, as long as we have the type of investor-state arbitration system as we know it, we can be sure of nothing, and the risks of international investment law encroaching on a state sovereign right and duty to regulate in the public interest will persist. Sorry for going over time. Thank you,
Okay.
Pascal.
Thank you very much, Nathalie. You raised so many issues about the interpretation of the standards of protection, the reformulation when the capital exporting states were responded in the cases, and finally you raised the exit the exit not the exit sorry, the ISDS methods as for settling to settle the disputes between the investors and the state. And we will discuss all that in the Q&A session. I leave the floor to Jimena Herrera, who will try to challenge Nathalie's position.
Thank you, Pascal, and thank you very much to the organizers for this opportunity. I will take some of the points of Nathalie and make other points that I have in mind. But the first thing is the premise that Nathalie presented is there has always been a right to regulate. I cannot agree more. I absolutely agree there's a right to regulate. The fact that it's included now in the treaties explicitly, I will come back to that. It could be another reason, but nobody, and I submit, nobody is, and I don't think the position of investors is to say there's not a right to regulate that has been recognized. Same as there is sovereign power to expropriate. The question is under which conditions and under which terms, whether compensation is due or not. So there's not a question that the state can regulate. The question is, how does it do it? How does it implement it? And what are what are the consequences of it? So there's this proposition that the right to regulate is the result of the policy of the states to take measures in public interest. Now, if that's the case, one supposes that the state as a rational entity should take into account that too when it enters into investment treaties. So part of that regulatory policy and balance of policies has to be taken into account when they enter into investment treaties. So now I do take Nathalie's point that there has been an evolution, there's no doubt. I wouldn't present this that, oh, okay, they found that this is the investment protection is a real threat to the right of regulate. I think that it may have been that there are some consequences that were unforeseeable, but that's not something that should be the burden then should be shifted on the investors. It was how they were designed, the investment treaties, how they were worded. That's something for which the responsibility lies on the states. Indeed, there has been interpretations and evolution in the terms of the substantive protections. But again, I submit that if that happens, and if there's a process of kind of filtering and refining the language, that's all fine and well. The question is, a state cannot ask an investor and attract the investment and then say, I change it at the mid of the game. As a state, you're absolutely entitled once to terminate the investment treaty in accordance to the law of the treaties, to set restrictions, but you cannot just at the end change the rules of the game, which is usually what happened in all these claims, in the investment claims. I mean, and again, here I'm taking the hat that I was giving, just for caveat. But for instance, that's the case, to just give an example, with the renewables cases in Europe. I mean, you give a guarantee, you give an incentive to invest, then you change it mid-time. There could be very well policies. It could well be that you consider that is a state, but that's something that the state has to deal with that responsibility, because otherwise what you're giving the state is just a blank check to do whatever without responsibility. And this again comes to what is the remedy when this happens? And again, you can regulate, you can change as a state, because quite often you have the argument that is you cannot freeze the state legislative or administrative powers by just imposing the treaty. Well, no, okay, you can change it as a state, but the consequences you have to compensate. That leads us to another point, which is basically this attempts to go from what it was, the idea of fair and equitable treatment and compensations for market value to some other kind of formulas for compensation, which I remember once seeing, I think it was in some of the old Eastern European countries, of what it's reasonable value or something of that sort. But as long as you have promised that if you take that action, you're going to compensate and give a fair compensation, that's what you have to complain with as a state. Now, given the many situations, and I will say particularly when we see, for instance, the situation in 2001 with Argentina, and we're speaking specifically about Latin America, where there are events that put the state in a difficult position. I mean, one understands the backlash, but then again, it's the solution to go and negate or present the position of the investors as if they were the evil and that they are taking advantage of the state? Or is the solution to really look at the articles of state responsibility and analyze the obligations that the state has undertaken under their optic? What is it? Is there really a wrongful act? Is it not? There was an actual defense of force majeure, state of necessity, etc. So there are ways to deal with this, and there are ways to deal within the same ambit of the complying with the undertakings of the state that are there. So where does this need to make it specific, the right to regulate comes from? I mean, from my point of view, and at the point of view of the investors that have been put to advocate, what can be seen now in new generations of treaties of these restrictive, specific expressions of the right of regulate, carve-outs in the sense that if the state takes measures, for instance, to protect the environment or social health or, the health, etc., then the measures should not be considered either as indirect expropriation or a violation of fair equitable treatment. I mean, frankly, in the abstract, what does it mean? Because you always need to have a real examine of what was the measure. And actually, the tribunals have had those tools to do it and have applied them. Is it disproportionate? Is it not? What are the elements that should play a role in that? That being said, and I do agree with Nathalie that there may be an issue with tribunals, but it's the issue with the right to regulate, or is it the issue with the preparation of the arbitrators sitting at the tribunal and the views and their knowledge or lack of knowledge of public international law? So I don't think that this is something that it's the problem per se of the investment treaties, but a different kind of problems. Quite often it has been said, also has been used, this concept that there should be a degree of great deference to the state, that the state should be allowed a margin of appreciation in considering what measures to take. And I submit that concept, first of all, it's imported from the European Court of Human Rights, and it was conceived in a different kind of setting, where also the the states, the European, the Union states have more of a say, or to put it this way, one of the points when you protect the investor, the foreign investor, is to say, well, this investor is coming to a field or coming to invest in this country where it has not had the power to select the government, and hence any measure in a way imposes a higher kind of burden of it. I mean, you can always impose burdens on the citizens, and as a state, you can always they have to support, but for the foreign investor is different. I think I'm being told that I'm running out of time. So I
you have 1 minute left, 1 minute. If not, we start with the Q&A because Jose is not appearing on the screen.
Okay. So finally to say, I mean, again, it's not a question of the right to regulate. It's a question of responsibility of the states and how they implemented it and how they word their obligations. Nobody forced them to have a certain kind of treaty with certain wording. So you can narrow it and take the decision to narrow it as you wish. Now, if you breach it, you have that has consequences.
Yes, thank you, Jimena, for your very interesting and very challenging position. You state that it's about wording the treaties, and then the state has a responsibility when he commits himself with what will be the commitment. It's on his responsibility. Now, Nathalie took the position that even that the standards of protection has been interpreted in a way that favor the foreign investors. And I think that there is a room, to find a middle way that, of course, the right of state to regulate, it could not be questioned, and you agree on that. Now, to put it into a treaty and to let the state defined in 3 or 4 pages exactly what he can do and what he cannot do is paving the way, of course, to be challenged by the investors on what he could do or what he could not do. So it's a way also of limiting the right of state to regulate. Now, being on compensation, we saw, and it's unquestionable, that the investors has been granted much more value of what should be given to them, considering also, and I'm challenging Ximena, that when the investors is entering into an agreement with the state, he should bear in mind that the state has national interest to protect and to put into its commitment or his feasibility that the law may be changed. And there is a room in the middle where the investors, the expectation of the investor is not to consider that the commitment will not be changed because of the sovereignty of the state. It's not, it's not a co-contractor as you and I. He has duties, and the foreign investors should bear in mind this from the beginning. It's an equilibrium with the state should has in mind when he commits himself into a treaties to know exactly to what extent he would limit his right of state to regulate by the way the wording of the provision. So there is a room to be followed in the middle of you. Now, I did not hear anything about the security, the exceptions, the general exceptions that are paving the way, that are responses to the state, to all the limits that are, has been put to the state to regulate. If you read the exceptions, unfortunately, it doesn't exist in the previous treaties, but it is the tendency. Is it an evolution or a revolution? You have to maybe to give the answer, but exceptions are here to protect the right of state to regulate and maybe to fix limit to investors' expectation. You have the national security exceptions that are the object are very specific, and it depends on the wording, and it gives the margin of appreciation of what you said, Jimena, about the state may take measure, nothing could prevent the state to take measure that it considers to be important or necessary or whatever, and all the interpretation by the tribunal is to what is the meaning of it considers to, to what is the state has the entire freedom to consider what it is necessary or not. And here also maybe we are shifting from the traditional standards of protection to this definition and the interpretation of these standards that are here to maybe reshift the balancing between the two parties. Do you want to intervene? If not, we follow up with the questions. But I would be very happy to have your ideas on that. Yes, Natalie.
Yeah, just the point you raised on exceptions. I did mention that there, exceptions, and as you just mentioned too, are becoming more and more frequent. However, we have the experience from the trade law context. One of the problems with exceptions is that you have the substantive rules, so and the burden of proof is shifted. So once you find a violation of the substantive rule, then you get the exception to kick in. One of the problems here is that it shifts the burden of proof, and it also shifts the burden of proof with respect to the right to regulate, because the right to regulate shouldn't be an exception. The right to regulate is the starting point, which means that the right to regulate has to be integrated into the different obligations already. So, I think that if I had the choice between adapting the substantive rules, protection rules, and amending those, integrating the right to regulate there, or leaving them as they are and then have the exceptions clauses, I would definitely go for changing the rules in the first place.
Okay, thank you, Natalie. Jimena?
Yes, thank you, Pascal. Yeah, when I was referring to the carve-outs and ways to kind of, set the limits of what can be done, I think my comment was that it's all good and well to put exceptions. The problem is that sometimes they are worded in such a general way that anything can go. So, and for instance, I give you an example. If we're talking about indigenous rights, the rights to the fact that the state can regulate to protect indigenous rights or things of that sort, and a specific aspect will be, for instance, which is also an obligation of the states that have exceeded or signed the ILO 169 directive of resolution, I don't remember now, about the protection of indigenous peoples and tribes. Take that in the mining context. When you have, the state has an obligation to comply with it, so you will say certain measures also are in accordance or the obligation with another treaty, but also sees that that's the way to deal with social conflicts, indigenous conflicts. The problem is, it's not whether they have the right or not, the manner in which it's implemented. And for instance, in some countries, it has not been only you have to do consultations for indigenous communities, but now you have to do consultations to any community that will be affected. So that gives rise to, for instance, a community could decide that they just don't want the mining. And would that be then comprised in the carve-out? Is that enough reason because I have generated this big carve-out? Again, I think that the analysis has to be more whether it's proportional, it's not, it's a legitimate interest. I mean, these are not new things. There are elements that have been there to kind of deal with these situations. You have also proposals, for instance, that we see in the Green Treaty that says, look, it doesn't matter if our proposal is the state has the right to regulate, and if it comes to an issue regarding health or environmental or you name it, of human rights, then it doesn't matter, even if there have been promises from the state to the investor that it's not to act in certain way, it doesn't matter. It can ignore them. And that's where I have an issue. And I think investors will have an issue because it's, okay, what are the parameters? You cannot tell me that I can just renege without more.
Yes, thank you, Jimena. This is what happened with the FET and all the standards of protection worded and so in that way that has been interpreted in different ways depending on the circumstances of the case. So saying that the state has the right to regulate is not without limit, of course. Let's be honest, and disproportionality, discrimination, and so on and so forth. Now, if we move to questions, I would like to ask Nathalie, if you had one reform proposal on how the best to protect the right to regulate in international investment law, what would it be? Unmute yourself, please, Nathalie. Thank you.
Sorry about that. It always happens once at every meeting. Sorry about that. I think the main point here is that I might be jumping ahead to the last panel, which is on investor-state dispute settlement. I do think that we can do all we want on substantive law, but in the end, you would have more security if you were relying on state-to-state dispute settlement, or if you were able to limit at least investor-state dispute settlement and its scope of application. Access to it could be limited as it is today under the USMCA, the NAFTA 2. Where the access to investor-state dispute settlement is much reduced. So it's really about either moving away from ISDS altogether and using state-to-state as Brazil is doing, or alternatively limiting its scope or relying on the exhaustion of local remedies first, because we do know that at the national level, you will have a better treatment of the different interests involved. And then you could go to the investor-state dispute settlement as a second possibility, as it is the case in the human rights law. So yes, I don't think we should give up on the substance, but the problem is really the connection to investor-state dispute settlement.
Yes, thank you, Nathalie. It's it's two. Jimena, any comments on that?
Well, I mean, I think that in the line of what Alvaro was saying at the beginning, that seems to be the proposal. It's kind of a regression to what was before. Let's go to diplomatic protection, basically, when the state has to espouse the claim of the investor. And let's get rid of the whole system that give the investor a direct action. Now, I mean, we know what was the evolution and how we ended up with the idea of having a investor-state dispute resolution system, and how I refer to AMCO with an agreement of, let's agree between the state and the investor that we're going to take it to a neutral jurisdiction, and we do it by agreement. So the question is, maybe we end up with a solution, but would that be that really a solution when there's clear a need that has been expressed and a condition for some of the investors that I get a neutral system? And also about the exhaustion of local remedies, as much as I can see that in some levels, okay, it's excessive to go to investment arbitration for for small measures. Then again, that's going back to the old system. So, I mean, how do we go? We maintain the general standards, but we get rid of the procedural, which in my view, it's not procedural, it's a substantive protection, the right to go to a neutral forum.
Okay, thank you. So if I may make a resume, a summary, it's to be much more involved in the standards of protection of the right of state to regulate, if I may say, and not investor, but I'm not talking about the investor, and then reformulate or wording it in such a way that leaves no such room to the interpretation of the arbitral tribunal, if there is arbitral tribunal that is involved in the situation to settle the issue. And at the end of the story is to have a neutral, let's say, multilateral court that would be of interest, that is a neutral forum to settle this kind of dispute. So the questions are here. There is no responses. And this is what is meant to be with the panel, is to raise interesting questions and not only to give responses. Thank you very much. I'm, Jose is not here. I tried to deal with this absence, but you have been wonderful. Thank you very much. And I will give the floor to Lilia Mooney, who will moderate the panel 2. Lilia is the Executive Director of the Center of the Advancement of the Rule of Law in the Americas, Carola. She also teaches courses in the areas of business, human rights, sustainability, ethics, and corporate social responsibility and governance. Over the course of her extensive career across the Americas, she has facilitated strategic dialogues and locally owned reform processes with academic institutions, civil society organizations, and communities, and international organizations. So maybe the facilitation would be also the solution. I give the floor to Lilia. And thank you very much.
Thank you very much. Can you hear me well? I hope so. Thank you very much, Dr. Pascala Coelho-Fan, for your introduction, and panelists for such a thoughtful and thought-provoking discussion with Ximena Herrera and Natalie Bernasconi. We're really now diving deeper in the waters of this discussion, and for walking us through the pros and cons and the challenges of the right of the state to regulate, or the responsibility at the same time, which is some of these issues we're going to be diving in much deeper as we are getting into this second panel. Just a quick mention, I would love to also thank T. Henley Hopkinson, who is the developmental editor of the Georgetown Journal of International Law, because he has also been instrumental in helping us put together this conference. We now move to this discussion on the recent trends calling for a rebalancing of rights and obligations that are indicating a shift on the traditional investment protection system. These trends are based on a common underlying theme that suggests that treaties on foreign investment in their traditional and current version place obligations solely on host states without equal commitments on the part of foreign investors. And at the heart of this discussion, two positions arise. From the perspective of investors, it is reasonable to assume that this is a long-term risk and it requires protection. We've heard that in the previous panel where Ximena was really advocating for this position. It's not a recognition of obligations. The decision to invest in a foreign country initiates a long-term relationship between an investor and the host country. And that generates an expectation on a return of the investment. Now, from the perspective of a state, it's also reasonable to assume that the object and purpose of the investment treaties is to attract foreign investment, and that requires creating the conditions necessary for the promotion of foreign investment and the removal of obstacles, while also acknowledging the host state's rights, not only obligations. So at the same time, in the midst of this discussion, proponents of a more balanced approach to the investment protection regime are giving more attention to substantive provisions, the dispute settlement mechanism, as Natalie was observing earlier, and other standards for protection at the host state level. No? These include the right, but also the duty. We heard that in the previous panel, the duty of the state to regulate in the public interest. And these examples of these is the field of environmental, human rights, and health protection law. Jimena spoke of ILO Convention 169, no, the right of indigenous communities to be consulted, no, particularly in the context of extraction of natural resources investments, no, and that opens up a whole discussion, no, on the right of consultation. Is it a procedural? Is it a substantive right? Do communities have the right to consent or not, or veto an investment? So what is the role vis-a-vis the investors here? So is there a space for a rebalancing, a recalibrating of rights and obligations of states and investors? Can it be achieved? So to get started with these initial questions, we have three distinguished panelists that have agreed to take on respectively the position of investors, the state, and also give us and help us explore how does a framework for a potential balanced approach might look like as we move forward with this conversation. So I will now proceed to introducing them in the order they will speak. First, we have Mr. Jose Manuel Garcia Represa, who is a partner at Deckard's Paris office. He's a specialist in international commercial and investment arbitration, with a particular focus on cases involving Europe and Latin America. Mr. Garcia Represa has represented parties in disputes arising out of contracts and investment treaties in the electricity sector, energy, construction, oil and gas, mining, post-M&A, purchase adjustments, joint ventures, telecommunications, insurance and risk coverage, sales and distribution contracts, and investment disputes. Mr. Garcia Represa also serves as an arbitrator. He has experience in cases involving multiple jurisdictions and procedural rules, and has appeared before the ICC, ICSID, and ad hoc UNCITRAL arbitral tribunals. He's a member of the ICC Task Force on Arbitration of Climate Change-related disputes and the president of the French chapter of the Club Español del Arbitraje. Following, we have Mariana Loza, and Mariana has recently been appointed as National Director of the Directorate of International Affairs and Disputes of the Treasury Attorney General's Office of the Argentine Republic. Before rejoining the Argentine legal team, she was a partner and regional head of international arbitration for Latin America at DLA Piper. And I say rejoining because she previously served as legal advisor for the Argentine Republic Attorney General's Office, and then as its deputy director, defending the Argentine Republic in its international disputes. At the Attorney General's Office, she represents Argentina in investment arbitration proceedings under the auspices of ICSID, UNCITRAL, and the ICC, and actively participates in the negotiation of international investment agreements on behalf of Argentina and in the current discussions at the working groups at ICSID and UNCITRAL. Professor Laurence Boisson de Jazournes is professor in international law at the Faculty of Law of the University of Geneva. She is the director of the Geneva LLM in International Dispute Settlement and co-director of the Center for International Dispute Settlement. In the field of dispute settlement, Professor Laurence has acted as counsel before the International Court of Justice and other dispute settlement fora. She's an arbitrator for ICSID and other arbitration fora as well. And she was a member of the CAS ad hoc division at the Pyeongchang 2018 Olympic Winter Games, which I think is really cool and amazing. In terms of process for this discussion, each speaker, again, we will follow the similar format. We'll have 10 minutes to make their presentations. I will alert each one of you when you have 2 minutes left, and kindly mark a hard stop at the 10 minutes mark. You will have more opportunities for expanding your presentations during the Q&A session and interact with each other as we see questions coming up from the audience. So Jose Manuel, please take it away.
Thank you very much, Lelia. Can you hear me?
Yes.
Thank you. Good morning or afternoon, everyone. I should start by saying that I've been entrusted with taking the position of investors. So this is for the purposes of this discussion, and I will, of course, be a bit provocative in that regard to launch the discussion. And the first thing I should say, Lily, I heard you mention, I think, a couple of times the word rebalancing. So I would certainly take issue with that, because I don't think we are talking about rebalancing. I think really what you are seeing in some of the most recent treaties is a shift. It's trying to shift onto the investors certain risks that should not be shifted. It's in essence adding another layer of obligations to investors, which I think serves no purpose, is counter to the incentives precisely of investment protection. And there are many reasons why there should not be obligations imposed on the investors in that regime. I think it's working perfectly well right now. There's no reason to change that. Now, the first thing I would say is that, of course, the system is aimed at protecting and promoting foreign investment. It is protecting the foreign investors and their investment. It's not about protecting the states. They do not need that regime for that. So if you look at the preamble of most of these treaties, including the most recent ones, it's clear that the purpose is to promote foreign direct investment. It has been for ages. There's no reason to change that. And why some call it imbalanced? I'll tell you why. Those treaties reflect the fact that the only one taking risks under those investments are the investors. So as you said, very, very rightly, investors are in for the long run. They commit significant resources, economic and time and effort, which they could dedicate to other investments in other regions of the world if the climate for investment protection is not sufficiently protective in a given jurisdiction. And if you start adding layers of obligations, what you will end up with is making those investments more costly. Riskier, and in essence, it's a deterrent to investment. So it runs clearly contrary to the object and purpose of investment treaty protection in the first place. It is a fact that investment protection, and we can then talk about some exceptions in modern treaties, is not conditional upon the investors complying with any obligations. That is not what the purpose of these treaties is about. If you think about, for example, the legality of the investment, well, the legality of the investment is not an obligation. It's really a requirement for investment protection. So you cannot access investment protection under the treaty if you have not, as an investor, complied with the local laws and regulations. If you have not complied at the time of making the investment. So that is not even a requirement that you continuously comply with local laws and regulations. For instance, it's also a fact that the international law of investment does not contain a clean hands requirement that has been tested by some states, and generally tribunals have considered that no such rule exists to impose obligations on the investors. And as I said, there's good reason for that. I guess another problem is, what would be the source under international law of the purported obligations on the investors? We, the investors, we're not subject to international law. We do not take part in negotiating and drafting treaties, of course. So what would be the source of obligations for us? That remains to be clarified, I think. There's certainly no international custom that would produce obligations on investors. And if anyone can elucidate such a custom, I'll be happy to consider it, but I haven't seen it. And I don't think anyone can prove that custom. There's been a lot of reference, for instance, to nowadays codes of corporate social responsibility. And as you know, and as I guess we will hear, there's some references in some of the modern treaties to such codes. But let's be clear, those are not conditions for investment protection. That is not how they should be certainly drafted. again, because there is no reason, I would say, that would justify adding another layer of obligations on the investors. The object and purpose of the treaties can be achieved and is being achieved without such obligations. So in essence, if any obligations are to be imposed on investors, and I think this is where we may see an evolution, it would have to be in state and investor negotiating contractual protections for their investment. If we want to consider, or if the system wants to consider investors having additional obligations, those obligations would have to be negotiated on an ad hoc basis for each particular investment, where the balance of obligations and rights would be achieved, where there would be a proper system for dispute resolution, all of that negotiated as equals. At the moment, investors and states are not equals, so it would be, I think, also tremendously unfair to impose additional obligations on investors other than what is already, for example, required under local laws. I think I will stop here to comply with the time limitations, reserving my time for the Q&A, which I think may be an interesting point. To summarize, the system was working well as it was. It would deter investment to add obligations. Any such obligations would have to be negotiated with the foreign investors and not unilaterally imposed through treaties that will not achieve their object and purpose. Thank you.
Thank you very much, Jose Manuel, for setting the stage of this dialogue and for representing the position of the investors. No, it's like, and you are talking about not a rebalancing of rights, but a shift, and I think that's a very important element that you bring to the discussion, and how the investment protection system will look like. No, and bringing this concept that we are, is at the heart of this discussion. No, it's like what are the rights vis-a-vis both actors, no, and how to engage in this new contractual engagement, if you will, no, and how would that look like? I would like to invite now Mariana, who will take the position of the state, not representing, of course, the government of Argentina, but speaking from that perspective, from the perspective of states in this conversation. At the same time, I also want to invite the people from the audience to put their questions on the chat. We're beginning to see those comments and questions, and we will also integrate them with the panelists in the discussion. Mariana, please take it away.
Thank you very much, Lilia. Well, first of all, I would like to thank Carola and Cretimi for such a kind invitation. It's really my pleasure to share this panel with these distinguished colleagues, and I'll try to stay to what I've thought before this presentation, but I must say that Jose Manuel has been very provocative and put very provocative questions and statements that are very interesting to discuss as well. So maybe I'll try to address some of those issues in my presentation, but in any event, we can then discuss during the Q&A. Well, as Lilia just said, I have been asked to address what are the legal obligations of the investors, if any, from a state point of view. So I will take the state side, although I do have experience in representing the state. As Lilia was saying, I want to clarify that the opinions that I give in my presentation do not necessarily represent the views of either Argentina or any of the states I'm representing, and maybe not even my views, but just for the discussion, academic discussion. So I would like to start my presentation by referring to what recent tribunal, the tribunal in the David Aven v. Dominican Republic case said when having to deal with a counterclaim last year Tribunal, in that case, highlighted that the investors enjoy by themselves a number of rights, both substantive and procedural rights, including, of course, the right to sue directly the host state when it breaches international obligations on foreign investments. And then it asked the question to itself, what about the investors' obligations arising of the investments according to international law? That was the expression. And I like this question because it talks about obligations according to international law. It does not limit to obligations under the treaty or under host or domestic law of the host state. I would like to double the questions and ask myself, and I've asked myself in preparation for this, for today, is do states have substantive and procedural rights against investors in relation to an investment according to international law? And the answer for today's purposes, of course, is yes, that investors do have obligations and the states do have rights in relation to investments according to international law. Of course, I will not go as extreme as to sustain that they are on an equal footing or that they should be on an equal footing. I do not dispute that BITs are asymmetric by nature, but I would like to argue in favor of this rebalancing of the system, or what I call in some previous discussions about where the system appears to seem going, which is a kind of more mature stage on investment law. So the question is, what are the obligations that investors have against states? I tried to write down what I think are those obligations, and the list goes as follows. And probably the first one is one that Jose Manuel mentioned, which is that investors do have substantive obligations in connection with the way an investment protected under a treaty is made and is performed. And by that, what I mean is that what we all know about these terms, that the investment has to be made in accordance with the laws and regulations of the host state. Most of us, of course, are aware that such obligations do not only arise from the express terms of the treaty, because tribunals have I guess, acknowledge as of now that even though there is no express term as to the in accordance with the law and regulations of the states, there is an obligation to comply with that law. I find it kind of provocative the way that Jose Manuel put it, because he said that that was not an obligation, that's a requirement to comply with the host state law in order to be protected under the treaty. But I think that if we start talking about requirements instead of obligation, that definitely may have an impact on the discussions that parties may have before a tribunal. I think that talking about just requirements may be less or maybe more weak than just talking about actual obligations by the investor. And also because that may have some impact as to when to discuss that issue. If you are talking about requirements, maybe that's something that probably goes to admissibility or jurisdiction. But if we start talking about obligations to comply with the host state during the performance of the investment, that may probably go to the merits, and when that's where you discuss about obligations. So maybe the perspective of the discussion is different. Other substantive obligations that may arise from the text of the treaty are those probably that can be derived from an umbrella clause, or even if we look at the more the newest treaties, not the old ones, as Natalie was saying, we can find that there are corporate accountability rules or anti-corruption clauses that perfectly goes directly to obligations on investors. A third group of substantive obligations are those arising out of international law in general terms. I mean, outside probably the more narrow scope of the treaty. And here I'm talking about obligations on human rights, on labor law, or environmental law. And we start seeing cases in which that's the debate. We see that states claim for compliance not only of human rights obligations, but also environmental laws and labor obligations on the ground that they are erga omnes obligations. There may be a discussion what's the scope of these erga omnes obligations, if it goes against all participants in the international community. If that's the position, definitely investors fall within that category. Then we could find substantive or procedural obligations, which are the ones that investors have to comply so they can trigger arbitration under a treaty. These obligations are usually seen as requirements, taking Jose Manuel's words, but I think that there is some room to consider as obligations the fact that an investor has to follow certain steps before triggering arbitration. And then, of course, well, there are procedural obligations on investors, but I won't go into that because that opens a whole world. So in light of these obligations that I've just enumerated, the current status of the debate does not seem to be so clear, and the states might have the feeling that there is a need to have express obligations in the treaties. And this brings me to another question, which is why states would like to include express obligations in a treaty. And I don't think, as Jose Manuel was saying, that this is because the states want to be protected. That's not probably the goal for including investors' obligation in a treaty. The reason probably goes in favor of the fact that both parties are able, if both parties are able to solve a dispute, the whole dispute, the ones that goes or that is in connection with states' obligations and the ones that are in connection with investors' obligation, that's probably benefits the whole relationship between the state and the investor. I mean, being able to solve all disputes in the most efficient and expeditious manner in a single forum is probably in favor of building a long-lasting relationship between the state and the investors. Of course, that seems to be the case of genuine investments, but in any event, that's what usually states are looking for when thinking about sustainable development. And in this point, I think that even it is kind of risky not to allow discussion about investors' obligations in before an international tribunal, because if an investor can, if a state cannot bring disputes against the investor before an arbitral tribunal, then the only available resource is domestic courts. And if the state goes into its domestic courts to claim against investors, that really creates a problem, because the state probably will be accused of harassing the investor to reopen the stage of investment protection prior to the Calvo clause. So it really creates a big problem, not allowing a state to bring the discussion about investors' obligations before the arbitral tribunal. Then I think the second reason is that it is in the benefit of building trustiness in arbitration as the appropriate dispute settlement mechanism for solving investor-state disputes, being able to discuss states' obligations as well as investors' obligations through arbitration instead of having multiple and parallel proceedings is definitely in favor of confidence that they have on arbitration, because they really get the feeling that it's a neutral fora to discuss the whole dispute. That probably even makes stronger the mechanism and able to resist more criticism, which is something that, well, nowadays we see. And here I also take a note of Jose Manuel's comments that the system is perfectly well right now, and probably because of all the criticism that we see, that might not be necessarily the case. And the third reason, and this is the final one, for including express obligations in treaties, is that having a more balanced system would probably tend to avoid frivolous claims. This is more collateral reason in comparison to the first the first two I mentioned. But I think that it's if we think the system as a forum to discuss only states' obligations, what probably happens is that the investors do not necessarily bring claims that are so genuine in nature. They may feel that, okay, let's try. Either we win or we don't win, but it's not that we lost. But if the state, if the investor knows that that forum can be used not only to discuss states' obligations, but also investors' obligations, then probably we would have more cases in which claims are more genuine. So on the final questions, and just Lilia, give me some idea.
Yes,
what?
Yes.
Oh, I'm finished. Okay.
No, go ahead.
Oh, just with the final question.
Final
okay.
Question, yeah.
Okay. So I would like to briefly address is what is the main obstacle to recognizing investors' obligations then? And here I think that the magic word appears as we see in the case law, which is consent, and lack of clear and unambiguous consent by the state and by the investor to submit the discussion about investors' obligations, even though we may well recognize that they have obligations, may be, I think, the big obstacle for actual recognition of those obligations. So I will be happy to address some of the case law.
Welcome back. No, this is great. Thank you so much, Mariana. And now we move towards inviting Professor Laurence Boisson de Chassourne to help us walk this discussion, no? From no obligations to moving to a more mature system where there seems to be arguments for obligations. How do we approach this conversation? And I want also to take notice of all the comments that are coming from the audience, and I invite Mariana and Jose Manuel also to look into them, and during the Q&A we will address them. Professor Laurence, welcome.
Thank you, Lelia. It's, I don't know from which perspective I'm going to speak now. It's not going to be, I think it's going to be from the academic perspective. So that's sitting in Geneva and listening to the discussion. First, I'd like to thank the CREDIMI and the Carola for inviting me. I think it's a fascinating discussion, and as always, I'm sure that we all share the same viewpoint: is that the truth is somewhere, but where it is, we have to look for it. So, the first point I'd like to mention is that this issue was not really an issue at the origin of the Washington Convention in the 60s, because at that time, in fact, investment arbitration was foreseen for contractual disputes. And when we have contracts, there can be rights and obligations for both parties. So the discussion that we have today, I think, is really linked to treaty arbitration. And what I'm going to say is that I think that there are regulatory trends Okay, and I use these words, we all use our own words, but it seems to me that we can see now regulatory trends which are highlighting that we're moving from only or sole treaty protection to what I would call investor protection, to investor responsibilization. Okay, and the word responsibilization is used because it seems to me in international law that investors and corporations more generally are increasingly perceived as actors that can contribute to the fulfillment of public interest issues. So that means that when we speak about responsibilization, it's an issue of responsibilization towards certain goals, certain objectives. And I think about the protection of the environment. I think about the fulfillment of human rights. I think about also the fight against corruption and so on. So why do I speak about trends? Because, and I'm going to mention some, from a treaty perspective, I think that we can see, and people are writing about it, we have a few treaties which are mentioning this aspect of investors being responsible, having certain obligations. And I'd like to mention the treaty dealing with investment protection of the Organization of the Islamic Conference, which is an example. In Africa, we have several initiatives, and Professor Mbe will surely mention them, but I think that the model treaty of SADC is one. The bilateral treaty between Morocco and Nigeria is another one. So there are some initiatives. It's in a specific context, but there are some initiatives. Now, it's not limited to the Middle East or to Africa, because in Europe, we have these trends. And it's interesting to be looking at the model bits of European countries like Norway, like Italy, like the Netherlands, because they are making, I'm going to use a word of José Manuel, which is the shift. They're shifting their attention to including certain obligations for investors. So what I think it's a treaty trend in different regions of the world, okay? Now, I think that there is another trend that was mentioned by José Manuel, which is related to corporate social responsibility. And for me, I don't want to deny the importance of these self-defined standards, because usually it's the companies which are defining the standards that they want to comply with. They also commit to abide to these standards when they become, they join the Global Compact of the United Nations, or the Equator Principles, and so on. So sometimes in treaties, we have references, and I would say, I would use my own words, but sometimes the investment treaties are capturing the social responsibility standards. And the big question, and I think for me, it's not yet a resolved question, is that does this capturing transform the social responsibility standards in sort of hard law obligations? And I have my doubts about this, but I think it's a point that we can discuss. And so if you look at, for example, the treaties negotiated by Brazil was looking at treaties with Malawi, with Mozambique, we have this capturing of the social responsibility standards. But sometimes they are just standalone standards. And I think that for me, it's going to be very difficult for a tribunal, if the parties argue on the basis of these standards, just not to look at them, not to take them into consideration. And so they play a sort of role of as benchmarks. Did you do what you committed to, and how did you do it, and so on. So I don't think it's a hard law perspective. It's another perspective of looking at what commitments entail when you're subscribing to these standards. Now, can we go a step further and consider that in international law, there would be certain obligations and so on? Are there rules of customary international law? Are there principles of law that we could identify? as an academic, I can refer to cases that have been discussed. I think the Obazer case is an interesting one, Obazer versus Argentina, because there you could feel that the tribunal tried to identify an obligation to provide water, but so I'm not really interested in the outcome of what the tribunal did was to build on the social standards commitments and to say, does it make an obligation of international law? And there, in passing, I think the tribunal said something very interesting, which is that there is a do no harm obligation. And there, which we call also the due diligence obligation. And for me, from my own perspective, I think that all actors of the international society are bound by this obligation of due diligence. Now, the further question is, what does it mean? And that's another issue that we can come back to. There is also another case which is interesting. It's the Aven versus Costa Rica case, and it was in relation to environmental standards. So there, the tribunal went through the DR-CAFTA treaty and said that through this treaty, in fact, investors had obligations in environmental law. And the tribunal said something interesting, said, in fact, when we speak about obligations of environmental law, we speak about erga omnes obligations. We are all the actors of the society are bound by these obligations. I put that on the table. Is it a trend that, can be discussed and so on? But I'd like to sum it, I'd like also to put this discussion in a broader context. Recently I've been working quite a lot on the SDGs, the Sustainable Development Goals, okay, and the agenda for sustainable development. All that was agreed by the international community in 2015. And when you look at what is going on within the United Nations, it's quite interesting because the states have subscribed to them, but in fact, the private sector is very, very active within the United Nations, and they're taking commitments, initiatives. There are a lot of public-private partnerships which are developed, and so on. So the question that I have is that when we're speaking about this responsibilization trend, shouldn't we place this discussion in a broader context, which is that we all are admitting that there are objectives that we should be reaching, and the obligations are going to be different from one another. I don't say that it's the same, but it seems to me that when you look at the documents of the United Nations, you see that private investment is core, is crucial for realizing the SDGs. And so the question would be, is it not something which goes in line with this responsibilization trend? Thank you.
Thank you very much, Laurence, for bringing this conversation together in the context of this responsibilization, no? and walking us through the tensions between this. Is a shift, or are states and investors really in need of rebalancing this conversation? No, very important. So if I may integrate this into the discussion. We're receiving lots of questions from the audience, and I'm asking Mariana, Jose, and Professor Laurence, of course, to look at them, and as we go through this Q&A, to integrate your comments and responses into those comments from the audience. No, and going back to Professor Laurence, one of the questions that you left us with, no, is what is the meaning? What is the meaning and the sort of the framework we should give to this the due diligence process? Now, in the context of all these initiatives that are calling for corporate social responsibility, mandatory human rights and environmental due diligence, both Jose Manuel and Mariana built on their arguments, no, the trend in this discussion. But how do we give meaning to this conversation, and meaning and also a movement towards implementation? I think that is very important. And I'm also building some of the comments that we received from the audience, no, for the participants. No, one of the examples, no, is the extractive industries. No, mining projects is probably 40 to 50% of the caseload. So in this case law, we know an industry that is challenged by this type of negative environmental and human rights impacts. So how do we give meaning to this conversation? That would be my first question to you, and then we can take on comments from Jose Manuel and Mariana. Yes, I think you are on mute.
Okay. Look, I think we should go back to the Ruggie principles as endorsed by the Human Rights Council. And when you look at what due diligence would mean, it's identification of problems, it's prevention, reparation. It seems to me that we've not really yet worked on all this. I think identification is an important issue that we should be aware. Prevention, but that is going to be a big question. What does it mean? And I think that we should be also linking that to the discussions about environment impact assessments, social impact assessments, and so on. I'm not so. I think we should also sort of circumscribe this obligation, because it can't be everything. Otherwise, it's almost impossible to decide to invest in a place. So I think that work is needed, so to give a more realistic tone to this notion. Wait a minute.
I think you're on mute, Lydia.
I'm inviting you, Jose Manuel and Mariana, to make any comments. They're then also integrating these questions, no?
Sure, no, with pleasure, if I may, Mariana, just because I didn't have a chance to reply to your very comprehensive presentation and brilliant presentation. I think one point I would note out of all of this, including our most recent discussion on the due diligence, is that, of course, for investors, a huge risk is uncertainty. So if we are going to end up having multiple regimes in different countries without clear guidance of what is to be expected, all of that uncertainty is more risk, more cost, and hence more return required by the investors to invest. And it's interesting to see in some treaties, you have requirements for the states not to lower the bar, for example, for environmental protection and others to attract investment. But that is inevitably what will happen if we go on to a system whereby the states will be competing against each other to attract investment on the basis of different levels of obligations on investors. Okay, so I go back to what Mariana said about consent, which I think was also the reason why, from the investor side, this contractualization of protections makes a lot of sense. Now, of course, then there may be discussions about, well, it's not the same thing having one of the GAFAs negotiating with a developing country or least developed country than having a small and medium enterprise negotiating. Well, maybe, but you already have national treatment clauses and most favored nation clauses in some of the treaties. So really, I think that the test is how much can be addressed truly at the international level. I mean, meaning by that the international community. So if we are consistent with AVEN in Costa Rica, there the tribunal, I believe, was sort of siding with the Urbacer tribunal and saying, yes, investors are no longer excluded or are not, I think they said, immune from becoming subjects of international law. And it was in particular to the environment, but they cited to the ICJ, saying that that position was based in view of the importance of the rights involved. All states can be held to have a legal interest in their protection. Well, if that's the case at all states, why should we not have a unique regime applicable to all states? That could be a question from the investor side. And in terms of how some of those goals you were mentioning, I think Professor Boisson-Chazourne was mentioning the Sustainable Development Goals, and for the diligence, the prevention and the identification principle. Well, right now, the the finance community, especially when it comes to financing extractive industries, is already requiring investors to comply, for example, with the Equator Principles. If you look at most of the major international banks, they have charts already assessing whether that investment has, for example, a social license to operate. So in essence, the investors and the financing community is already implementing that without a need for having another layer of what I called not just rebalancing, but really a shifting of the risk more onto investors. And my final point is to illustrate the point about uncertainty. Professor Vasson Chazourde mentioned the example, for example, for investment protection of the Nigeria-Morocco BIT. Well, that treaty has an article specific to impact assessment, where it says that the investor has to comply with environmental assessment screening and assessment purposes applicable to the investment prior to the establishment of the investment. Okay, but then he goes on to say, as required by the laws of the host state for such investments, or the laws of the home state, whichever is more rigorous in relation to the investment. So that will also add uncertainty as some of those regulations will be evolving. And I think what we also have here is a problem of what type of regulation you put in. Final comment on the extractive industries, because there was a question about it in the chat about, for example, the Canadian exception, or the Canada putting in some of these its treaties or FTAs similar exception to GATT Article 20. There was, I think, last week an award in the Eco Oro mining caves against Colombia that precisely addressed that point with an interesting dissenting opinion. I have not had the chance of looking at it in detail yet, but an interesting dissenting opinion of Professor Philippe Sanz. So I will recommend the audience, if they're interested in that point, to see how that exception was addressed in that context.
Well, I mean, too many things to say, but I don't want to. I mean, try to organize to all the comments from Professor Vasson Chazourde and Jose Manuel. Well, I would agree that uncertainty is not good for the whole system. I mean, neither for the investor nor the state, because probably the uncertainty is always linked to, well, it's not good for investors and they don't want to, they really feel very uncomfortable when a state is not certain as to its conduct. But the same goes to the state, because if there is uncertainty, and by that I mean if there is a lack of identifications of what are the obligations, then the state sometimes, I have the feeling that is not has not a clear understanding of what are the limits within which it can fairly conduct and without breaching any rights. So I think that what was said about having, I mean, the identification of what are the obligations is crucial. Jose Manuel was just referring, and it mentioned it in the presentation, that probably we could have this discussion of investors' obligations within a context of contractualization. I couldn't agree more in the sense that the kind of discussions that we have on investors' obligations when talking about investment law definitely is not the same as we have when we have, for instance, a PPP, which is a contract between the state and the investor, and all obligations are clear. And then if there is a dispute, either way, because of failure to comply with rules, either way, there is no discussion. I mean, that arbitration should, is the proper mechanism. So probably what we should start thinking about is, I understand that, and it was said that we have a broader context of investors' obligations, but probably we should start thinking about how to be sure that we have a clear understanding of what those obligations are, either for the investor and for the states benefit. That discussion could be then brought before an international tribunal, or I've just read a comment about bringing an international claim before the domestic court. Of course, I understand that there are many reasons for not having the discussion before a domestic court, but in any event, there are countries that are prepared to have that discussion because of the hierarchy that international treaties, such as an investment treaty, may have in a particular juridical or legal system. So, I mean, at least in some cases, and I can speak, for instance, in the case of Argentina, a discussion on international law could be, I mean, brought before domestic courts. Of course, I understand all the reasons why that would not be what either investor and the state want.
Professor Laurence?
I think the uncertainty is the key word, because there is uncertainty as to what really should be the scope of these obligations, if there were any, and how to put them in place. And I think there's also the issue of the legal status. And so for me, the question is that I said it's a regulatory trend, and I think we still need to work on these issues. And we don't have yet clear answers.
Excellent. And in the context of this discussion, one of the questions that also come to the table: what is the role of tribunals in respecting investors or recognizing investors' legal obligations? Can a tribunal go beyond the terms of an investment treaty? We briefly covered this, but I would be curious to think what the three of you think about this.
Well, I'll take the chance. I'll say no, of course. You know, especially in the exit context, if you're thinking about annulment risk, I think that would be certainly an annulment risk. I think I had mentioned a moment ago the dissent by Professor Sanz in the Eco Oro. I think precisely one of his points was that in not applying, as he thought it should have been applied, the exception for environmental protection measures, there was a manifest disregard of the applicable law in his view. So I do not think it is for tribunals to craft new rights or obligations that are not in those treaties. Absolutely, that is not the role of tribunals. And there has been some debate, even in tribunals, and you can find that in certain awards, whether the mission of a tribunal is just to adjudicate the dispute before them or try to contribute to the development of a uniform body of investments, international investment law. And some arbitrators view the role as more of creating or adding to a uniform body of law. From the investor side, which I'm presenting here, the tribunal should limit itself to addressing the claims before it, the treaty or whatever applicable law is before it, period. Otherwise, you add uncertainty to the whole process.
Well, I think that probably it depends. And that's the easy answer, but no, I mean, it depends, because if we are talking about probably the new area of PIT, probably we will be lucky, sorry, to have the more explicit obligations in a treaty. But the problem probably arises if we have to analyze one of the old treaties, in which we can find these general expressions, like, for instance, reference to investment made in accordance with law of the host states, or that the applicable law is international law, not only the treaty. So I think that, for instance, those treaties in which there is a reference to international law, or even the law of the host state, in the clause that relates to the applicable law, there is some room for tribunals to, of course, give content to that. And if we are talking that investors as participants in the international community has not only rights, including the right to pursue a claim against a state before an international tribunal, but also are liable of because of the obligations they have. I think that definitely tribunals have an important role in that regard. I mean, to provide content to certain expressions that there are in BITs. We've seen that, for instance, with the FED. I mean, with the whole discussion about legitimate expectations, we can see that probably it has been the arbitrators, the ones that have provided more content, and then the reaction of the states in the treaties is something that follow the decisions from arbitrary tribunals. So probably the arbitrators might take the lead on this, and then, well, states go behind with amending treaties.
Right. Thank you so much, Mariana. I know we're getting to the close of the panel, but Professor Laurence, I would like to give you the floor for your comments, and yeah.
Yeah, no, I was listening, and I was thinking that when you go to ICSID, you have Article 42, which provides for different sources of international law, and there is a purpose and a meaning to such a provision in the convention. So the treaty, of course, is very important, but there are other sources of international which can play a role. I think it's also going to be, it's not just the responsibility of the tribunal, it's also the responsibility of the parties which are arguing before tribunal, and the way they are presenting and their viewpoints. Now, thinking about certain cases of counterclaims, I think counterclaims, I hope that we're going to have more practice to better understand how it can work, but it's true that we have the Burlington case and the Perenco case, and this was based on domestic law because there was an agreement between the two parties in each case. But maybe that one day when we have a counterclaim which is admissible, it could be established on the basis of international law. And I think it's what the Urbaza tribunal attempted to do, but didn't do it because it couldn't find an obligation of international law. Thanks.
Thank you very much. I could continue this conversation for hours with the three of you, no? But unfortunately, we have to move on with the next panel. But I think we began raising very important questions. And one of the key elements, as Professor Laurence Boisson de Jasson was mentioned, is legal certainty, no? And how would legal certainty would look, no, in this more rebalance approach, if we're going to aim for one. And in that context, at the same time, how do we get to a little bit of more of a mature stage, as Mariana was saying, in a context where, as Jose Manuel was reminding us again, legal certainty for investors in a context where there is much more active state presence. I think one of the questions Professor Santos left us with at the opening was how are we going to move towards implementing these commitments, these potential commitments in a more rebalanced approach, and in a context that Professor Laurence Boisson de Jasson also talked about the responsabilization in a context like move forward with this. So how are we going to implement this? These are questions that we are left with. We will continue engaging further. And I want to thank our three distinguished panelists for taking the time to join us today in the midst of your busy schedules. And I also would like now to invite our next panel to join us, and our moderator chair for that panel, I will briefly introduce him. Mr. Álvaro Galindo is the newly appointed Dean of the School of Law at the University of the Americas in Quito, Ecuador. He's a partner at Carminiani Perez Abogados, an adjunct professor at Georgetown Law Center, of which he's also an alum. He's a member of the list of arbitrators at ICSID and member of the International Court of Arbitration and the International Chamber of Commerce. Dean Galindo, please take it away. And I also want to thank the audience for your thought-provoking questions, and we've tried to address some of them. Thank you very much.
Thank you very much, Lelia. It's my pleasure to introduce panel 3 in this very interesting event organized by Credimi and Carola from Georgetown University. First, I would like to introduce my panelists. As you all know, the theme that will be discussed today is the dispute settlement mechanism in question between the prevention and the management. And for this, we have invited 3 terrific academics and practitioners that will enlighten the discussion. First, we have Ana Maria Ordóñez. She is the head of Colombia's International Litigation Division at the state's Legal Defense Agency of Colombia. She is a lawyer from the Pontificia Universidad Javeriana with an LLM from King's College London. She has acquired experience in international arbitration and litigation through her work in local and global law firms. She began her career in public service in Colombia more than 8 years ago. And as the head of the International Litigation Division at the agency, she structured Colombia's legal defense model and faced the first investment disputes filed against the state. And for the past 4 years, she has led the work of the agency to consolidate what has been a successful defense model implemented by Colombia. Ana Maria will have the task to cover the way ISDS as a dispute settlement mechanism can have prevention potential, inter alia when unfavorable awards discourage new applications, and how the cooling off period has a potential to prevent ISDS disputes. She will also refer to relevant experience Colombia has had in its ISDS cases and that experience. Then we will move to Alexi Moore. I think all know Alexi, but I will make a brief presentation. He has served as Paris Council, President of the Tribunal, co-arbitrator, sole arbitrator, or expert in more than 260 international arbitrations, both ad hoc and before most international arbitral institutions in the world. He established his own arbitration practice in May 2015 after having founded Castaldi, Moore and Partners in 1996, now a 35-lawyer firm specializing in arbitration and dispute resolution. He is the author of numerous books and publications in the field of international business law, private international law, and arbitration law. Alexi was the president of the ICC International Court of Arbitration from July 2015 until 30th June 2021. And I had the honor to serve in the court during his presidency. And he was the vice president of the court from 2009 to 2015. He was the vice president of the ICC Institute of World Business Law from 2011 to 2015. Alexi will have the task to cover mandatory mediation in ISDS and the way this could have an impact on the number of cases that will require to be settled through arbitration. Finally, but not the least, Anna Juban-Brett. Anna is the Secretary of the United Nations Commission on International Trade Law, UNCITRAL, and the Director of the International Trade Law Division in the Office of Legal Affairs of the United Nations. which functions as the substantive secretariat for UNCITRAL. She is the 9th secretary to the Commission since it was established by the General Assembly of the United Nations in 1966. Prior to her appointment on 24th November 2017, Ms. Dupin-Brett practiced law in Paris, specializing in international investment law and investment dispute resolution. She has served as counsel, arbitrator, mediator in several international investment disputes. She has worked under ICSID, UNCITRAL, and ICC dispute arbitration rules. And prior to 2011, and for 15 years, Ms. Dupin-Brett was the senior legal advisor for the United Nations Conference on Trade and Development. And finally, Ana will comment briefly on Ana Maria's and Alexis' presentations, and will refer to dispute prevention, dispute management, and mediation in ISDS. This will be put in context with the work advanced under the umbrella of the Working Group 3 at UNCITRAL, and where the Latin American countries are in the development of mediation and ISDS and the best practices to implement mediation as part of the ISDS tools. I invite our audience to send their questions through the Q&A, and I will try to convey them in due time to our panelists. So please, Ana Maria, I invite you to make your comments for 10 minutes, and then we will move on. Thank you, Ana Maria.
Thank you, Alvaro. Good morning from Colombia to everyone. I want to thank Carola and Karimi for the opportunity to intervene in this discussion, and to all the attendees for your attention. Through my intervention, I will speak briefly on various key issues related to the prevention of ISDS disputes through settlement and the issues that raise when attempting to settle disputes from the state point of view. I will also briefly comment on the potential of ISDS awards as a source of prevention. I want to start first with Colombia's approach to amicable settlement in international adjudication, just as a source of reference. Colombia has generally favored amicable settlement when managing international disputes where the state's international responsibility is at play. For example, before ICJ, we have the prominent example of the case concerning aerial herbicide spraying instituted by Ecuador, which was settled some weeks before the initiation of the oral hearings. Notwithstanding the resources already used by the parties on the court, the president of the ICJ expressly commended this effort, which derived in the case being discontinued. More recently, actually, some weeks ago, Colombia's International Legal Defense Team was recognized by an NGO focused on the promotion of excellency in the administration of justice for our efforts to reach amicable settlements in cases before the Inter-American System of Human Rights. Both the Inter-American Commission and Court have commended our efforts in this regard. I am using these examples just to confirm that Colombia is indeed a state very open to settlement of disputes through negotiation. But let's turn now to our practice in international arbitration. What has happened? In order to obtain an amicable agreement, it is important that the negotiation process is entered in every case in good faith and aiming to reach reasonable, and I want to highlight this, a reasonable solution. We must not forget that ISDS discussions usually revolve around grand public policy decisions, so proposals submitted at this stage must be respectful and deferent of each state's institutional organization and decisions. It is very difficult for a state to settle just because the investor is not satisfied with internal decisions made by relevant authorities according with the law in place when the investor decided to invest, for example. So at this point, we want to refer to recent awards issued in Colombian cases. In one case, the tribunal confirmed, for example, that there was simply not protected right under Colombian law. So for the agency in charge of negotiations, it would have been very difficult to recognize a right that was not even in place domestically. In others, it was recognized that the conditions of consent were evidently not met. And in others, we were convinced that our institutions acted in accordance with domestic law in a non-discriminatory way and in pursuit of a legitimate purpose. So, as I was saying, it is difficult for a state to enter into negotiations when investors submit proposals that cannot be accepted regardless of the merits of the investor's claim. Say, for example, settlement offers for the same amount than the arbitral claim, and instances where officers in charge of negotiations are legally prevented from accepting the course of actions proposed by the investor. So as a general recommendation, if settlement is seriously considered by investors, they should exercise due diligence to come up with proposals that are reasonable and legally possible. ISDS does not create a paralegality where investors can receive benefits not otherwise available. For example, they cannot look or pretend to obtain a promise that an investor would not be investigated by an institution whose main function is to investigate them. International arbitration is not a mechanism that allows investors to abstract from the laws and regulations of the state they are investing in. So these are some ideas that are just addressed to achieve a good use of the negotiation stage to its fullest, and not just for the purposes of exhausting one of the fundamental prerequisites of our consent to investor-state arbitration. So I'm going to refer now, having mentioned these recommendations or explained why it is difficult in some cases for states to achieve settlement in ISDS disputes. I will just mention the amicable settlement in Colombia's legislation. Turning now to the question of management of these disputes when they are in the pre-arbitral and arbitral stage, I want to make 2 points in this regard. First, I will refer to Colombia's management of disputes for the long period when we had no cases listed, and in second instance, to the contribution of legislation to our managerial capabilities. First, Colombia was able to stay out of the arbitration stage, managing the potential disputes at the negotiation level. This particular circumstance gave Colombia sufficient time to prepare, which was in itself a success of the prevention strategy from our colleagues at the Ministry of Commerce. During that period, we learned from the practice of other states, including Latin American ones, and that allowed us to prepare for what it was inevitable. Now, at this time, we have 14 active proceedings, and we can benefit from what we learned in those years to do our best in defending the state's interest. And second, internal legislation has evolved, providing the State Defense Agency with the tools necessary to address the new needs. Currently, the State Defense Agency is in charge of the pre-arbitral stage as well, including the negotiation and cooling off period. This allows for a coherent approach to ISDS disputes and, more importantly, to secure consistency in the management of international disputes regardless of the field. And in the 3 minutes that are left, I would like to mention the importance that we have identified that investment adjudication in the form of awards as a source of prevention. Because we have an expectation actually, and it is that there should be a relationship between adjudication and prevention, and in particular on the way arbitral awards have the potential to discourage frivolous or meritless claims as long as the decisions show deference and respect to the state's right to regulate, and obviously to the consent that is incorporated in each one of the treaties. Colombia's recent awards show that investors face real economic risks when they decide to pursue claims, and we know that investors need to be aware of using properly their budget. So we are convinced that as long as arbitrators are respectful and put into place particular care on being respectful and deferent on decisions that are properly obviously made by states, awards can be a great source of prevention of disputes. And with this, I finish my 10 minutes, and I'm happy to respond to any questions that the audience might have.
Thank you very much, Ana Maria, for this excellent presentation that sets the stage for a very interesting discussion. And before I pass the floor to Alexi, I would like to ask you just one question that came to my mind as a result of what you have shared with us on Colombia's experience on ISDS. I remember that in the 90s, beginning of the 2000s, Colombia was out of the hook from investor-state dispute settlement because of a decision by the Constitutional Court of Colombia that basically stopped the government from ratifying many bilateral investment treaties that were negotiated and signed by the Colombian government. And Colombia had many years to prepare, looking at what was happening to its neighboring countries before investor-state dispute settlement cases. And then this problem, this legal constitutional problem, was solved, and basically Colombia in the last 10 years has ratified several bilateral investment treaties. Do you think that the position of Colombia was better off being out of the hook of the investor-state dispute settlement in attracting foreign investment? Or does the implementation of these bilateral investment treaties did have an impact on attracting foreign investment to the country? Ana Maria.
Oh, sorry, I was muted. Thank you, Alvaro. I think that Colombia has very good language in its treaties, and I think it's not about being in a better position. I think it's a decision that was made by Colombia to enter into the second phase of good negotiated treaties in order to attract investment. But it is very clear that it's like that ISDS is an option, it's a prerogative that we gave to investors in order to attract the investment that we want to have in Colombia in order to pursue our SDGs. So I wouldn't say we are not, it's not about being in a better position. What we can say is that we do protect, and we are convinced that that international investment is very important for the development of our country. We entered into the ISDS world by second generation agreements. There are the conditions that are set. So what we are doing is that we are trying to obtain balance in respecting and granting the investors' rights. But at the same time, we take very serious the right to regulate of the state and the defense of the decisions that are properly made.
Thank you very much, Ana Maria. This is very important for the discussion. Alexi, I invite you to make your 10-minute presentation, and thank you very much for sharing your thoughts with us.
Well, Alvaro, thank you. It's a pleasure to be with you today. I've been asked by Alvaro to speak for 10 minutes about a subject of which I have absolutely no experience, which is mediation in investment arbitration. I have some experience as arbitrator in investment arbitration, but I've never participated to mediation in an investment case, although I did in a couple of commercial cases. My only experience, I would say, is that I am chairing the tribunal in a case which is called Barrick, Papua New Guinea, and some months ago we had a notice that the case was about to be withdrawn because of a successful conciliation proceedings, very ably conducted by a panel, I think, chaired by our friend Joe Tirado. So that proves that it works well, and in fact there is raising interest and raising focus at the moment on amicable settlement in investment arbitration. Seen the IBA rules, of course, the works of Ancestral Working Group 3, and more broadly the discussion of the effects of the Singapore Convention of 3 years ago on investment cases, on which I will say a word later. So there is increased focus on it. Nonetheless, mandatory conciliation or mandatory mediation is so far an unknown. There has been recently a survey showing that on 2,500 mapped treaties or agreements, 627 contain a provision for voluntary ADR, conciliation or mediation, but none contain a provision for compulsory mediation or conciliation. Is that good? I think mediation conciliation is good, certainly, without any doubt. It can, as I said, lead to successful settlements. And in fact, I had the experience of this in the context of a couple of commercial arbitrations, sitting in front of a third party to try to narrow the parties' positions may have the effect of provoking a virtuous circle. It is different that parties talk directly, as it happens in the cooling off period, and that they sit around the table with a certain neutral party trying to bridge the gap between them. It can have very positive effects. Whether mandatory mediation conciliation adds something, I would say yes, to the extent that parties may be unwilling to attempt settlement, and forcing them to do so may have, as I said, the effect of unblocking the situation. Now, it may have also undesirable effect. There is the potential for increased procedural objections. There may be argument at some point that the procedure has not been complied with, that it has not been complied with according to the parties' agreement. There may also be concerns, and I take what Anna Maria just said, not everything can be settled. There may be concerns on the part of the state about transparency, because of course there is conciliation and mediation will not offer the same level of transparency as arbitration, and of course for the state in certain occurrences in particular where at stake are human rights claims and situations like this, or climate change claims, it may put the state in a difficult situation. Now, what I would like to do in the few minutes that I have is to raise perhaps three questions, assuming that more treaties, and in fact there are two treaties I think that have adopted mandatory conciliation. I don't have them. One is the comprehensive agreement between Indonesia and Australia, and the other one I think is the Hong Kong, is a treaty signed by Hong Kong which provides for mandatory conciliation. Now I don't have the exact name of the other state in mind, but we will come back. Now what I'd like to do is to raise three questions. The first goes to the time at which the conciliation mediation should take place. Of course, if this duplicates the cooling off period, it is only negative because it adds time and complication to the procedure. So I would suggest that if the state parties are to agree to mandatory mediation or conciliation, conciliation should take place in lieu of the cooling off period. I mean, there is no point in having direct conflict between the parties and then having a conciliation. Or if that is not the case, perhaps they should be thinking on how those things articulate. And I think that mandatory mediation or conciliation should take place within the temporary framework, which is now provided for cooling off periods, which is generally 6 months. So this needs to be organized. The second thing is that there should be an agreement in advance on the rules to be followed, because if there is no agreement, then it can only result in complications. One thing is for the parties to sit together and discuss. Another thing is to have a process for the appointment of a neutral and agreeing on the role that this neutral will fulfill, agrees on the conditions for his or her neutrality or impartiality. The IBA rules are very good rules. There are others, but I think that if the state parties are to embark into an agreement for compulsory mediation, which is something that involves the intervention of a third party, there should be an agreement on the procedural rules to be followed for this. The second question is that of the consequences of non-fulfillment. For example, a refusal by one of the parties, the investor, for example, to submit to the mandatory mediation process. Is it then a question of jurisdiction? Is it a question of admissibility? My own initial and very superficial view would be to say that it should be a question of admissibility rather than jurisdiction, but surely these clauses will generate discussions on that question. And the third point is enforcement of settlements. You all know the Singapore Convention. I think there will be, or there may be, a question in the future as to, in particular, when European countries are involved, as to whether the European Union with ACMEA will like EU states to be part of the Singapore Convention, and whether they will like settlements made in instances where the EU may consider the arbitration to be invalid, to be enforced pursuant to the Singapore Convention. That is very, very briefly what I wanted to say.
Thank you very much, Alexei. This has been a very interesting presentation on this issue of mandatory mediation in ISDS. And I do have a question for you, Alexei, before we go to Anna. And it is in terms of the experience of the states in dealing with ISDS disputes. I have seen that one of the problems to reach settlement when the arbitration proceedings are unfolding is particularly when the state has to present its own position. For example, in its answer to the notice of arbitration, or later on with the memorial or counter memorial on the merits. And it is more difficult for the states to try to reach settlement and even to initiate discussions once the state has answered to the merits of the claim. And you mentioned that the cooling off period, if the mediation is to have an important place on these proceedings, somehow should take the place of the cooling off period. So within this framework, my question is for you is, when do you think the mediation or the mandatory mediation should take place, and how the evolving of the arbitration proceeding could have an impact, particularly on the state and its willingness to reach a settlement with the investor?
Yes, well, I'd like to say two things on this. The first is that we are now talking about mandatory mediation. Of course, non-compulsory mediation can take place at any time. The parties can always agree to stay the arbitration once the statement of defense has been submitted by the state, to say, well, let's agree to hold on for a couple of months and try settlement. This is, of course, always possible. Now, mandatory mediation has to be agreed in advance. So you are agreeing on something that has to take place. I don't think that it is reasonable to agree in advance that mandatory mediation will take place in the middle of the arbitration proceedings for two reasons. First, because it is an element of delay, and second, because you may then be at a point in time when the opposition between the parties may have already increased. The party will have started to litigate, and I'm not sure that this is the best point. Now, we should be mindful, and that's the second thing that I'd like to say, that mediation is an animal that is completely different from arbitration, and a mediator is not an arbitrator. The point here is not, of course, the parties should know what they're talking about, but they're supposed at the beginning of the arbitration to know what they're talking about, because there is a notice on the part of the claimant to the state, and the state, of course, knows what the claimant wants, and the claimant, of course, knows its case. But the point in mediation is not for the parties to argue their case and to know what the legal arguments will be, and the point for the mediator is also not to resolve the dispute by saying what the law says. The role for the mediator is to bridge the gap to the parties. It's something that has a psychological aspect, it has a business aspect as much as a legal aspect. So the fact that the arbitration may not have started at that point, I think is not decisive, and precisely because the parties will not have started to incur costs, because the parties will not have started to litigate one against the other, with the, of course, the element of adversariness that this supposes. I think that doing it sooner rather than later increases the chance of a successful mediation. But again, perhaps the decisive argument is that if we're talking about mandatory mediation, you have to agree to it beforehand. So you need to agree on when it will take place. And I'm not sure that it's feasible to agree in a treaty that the arbitration will stop in the middle of the proceedings to attend mediation.
Thank you very much, Alexi. We now give the floor to Anna.
The treaty I was thinking about is Hong Kong.
Yes.
Anyway, the treaty I was mentioning, which I couldn't remember, now I do remember, sorry, the Alzheimer, is the treaty between Hong Kong and the United Arab Emirates.
Between Hong Kong?
UAE.
And
United
the UAE.
Arab Emirates. Sorry for this.
Thank you very much. Well taken. Anna, please take the 10 minutes for your presentation, and the floor is yours. You are muted. Let's see if technical support will help us. Perfect.
Yeah,
thank you.
The usual phrase in these webinars, you're muted, or can you hear me? So thank you very much to the organizers, particularly Crédit Me, our French national flag is waving, and also the hosts in Georgetown for organizing this event. And I'm very glad to see so many faces of good old friends, of delegates in UNCITRAL's Working Group 3. And I'm also very grateful for this opportunity that is given to me to talk about the issues that are on our plate in UNCITRAL's Working Group 3, but taking my hat as the Secretary of UNCITRAL off and speak more in my personal capacity, or put in some personal thoughts as much as I can. I have, just before getting into the points that have been assigned to me by the organizers, I wanted to share with you that I listened carefully to the two preceding panels, and it made me think of the importance of these two aspects of the international framework, also from the point of view of the reform of ISDS that we have received as a mandate and we're trying to advance. We are at the delivery phase now in Working Group 3, and during the preparation of the plan for the different elements to be advanced in the reform, a number of states made a strong call for paying attention to what they call the cross-cutting issues. And those cross-cutting issues are the ones that are not only or not principally procedural, but that must also be looked at in the procedural reform. And one of them, of course, is to preserve the state's right to regulate. And the other one is the possibility for the state to bring counterclaims. So here it's clear that you have to bear in mind that the reform is not about including provisions, substantive provisions into the treaties that are not in the treaties yet, but also making sure that you provide in the reform you cater for the possibility of a new generation or new generations with an S of treaties or of partnerships or of agreements or contracts or whatever to include these elements, these substantive elements of protection of the state's right to regulate and the possibility to bring counterclaims. So I think that it's very important that although it is not, it is only a starting trend, as Laurence was saying, we in the reform part must really look at that as something that is going to come and make it possible to have more of these provisions, more investors' obligations, more possibility for counterclaims, and more issues of the state's right to regulate. Now, on the points that have been discussed by my two fellow panelists, we've heard from Ana Maria that states have made great progress in their preparedness and their responsiveness to investment disputes. That's very much the case in the region, in your region. It's not really the case in many other regions. And I wish there were more possibilities for exchanges, because we see, and as Ana Maria rightly said, Colombia has learned a lot from others. When I was still with UNCTAD in the years 2005 around, I worked with Peru in the establishment of their SICRESI, which was the system to respond and to manage disputes. And from SICRESI, a lot of other countries, be it Colombia, the Dominican Republic, or many other countries in the region, have learned on what are the different ways of managing these disputes. And this is, of course, for the management part. And in this regard, I think there is a lot of room and need for allowing others to also learn from this experience and from the good or the best practices. When it comes to dispute prevention, it's of course less obvious, because there the experiences have been mixed, and in the treaties themselves there are provisions for dialogue, and there is a lot of good practice that can be shared, but it is more, I would say, it is more scattered and more also specific to the organization and the approach of some countries. Now, how do we take that on board in the Working Group 3 and in the different reform options? There is a reform option that has been called for very early on, which is to strengthen dispute prevention policies and to make sure that states have better ways to prevent disputes from arising. And of course, quite logically, as there are two sub-elements, and you will find that in the working papers that I had before me, and particularly I would call your attention to a working paper 190, of 15 January 2020, which is about dispute prevention and mitigation, means of alternative dispute resolution, where you have really two aspects. One is the dispute prevention at the domestic level, and the other one is to strengthen access to alternative dispute resolution. Now, on dispute prevention, there is, of course, the aspect of avoiding escalation into a full-fledged ISDS arbitration. And there we have already prepared provisions and reform options to allow the recourse to alternatives to arbitration, because when we say ADR in the ISDS context, we're talking about alternatives to arbitration and not alternatives to court cases. And there are some good examples in the region. For example, Brazil, we are very fortunate to have a strong engagement on the part of Brazil in the reform of ISDS, although, you know, they could consider that they don't really need to engage in reforming ISDS because they don't have ISDS in the first place. But by not allowing ISDS, they have, of course, developed or strengthened these other means, for example, addressing your claims to an ombudsman. And all of this contributes, and there's a lot of good experience and policies to be shared in the working group. Another reform option that is being developed and which very much also takes into account this dispute prevention that states have, the practice of dispute prevention that states have developed over the years, is the establishment of an advisory center, which is more meant to cater for those least developed countries that have one case every 10 years, or that have really, you know, weaker institutions or weaker agencies and even budgets to be able to face these claims. And this is also something that is not new, because there was an original project for Latin America 10 years ago, when the region was still in the early steps and stages of ISDS and dispute management and prevention. Now, the other aspect which we are going to focus very much on, because it has been requested by the member states, is of course recourse to mediation. And it draws, as Alexis mentioned, on UNCITRAL's work on mediation, including the very complete framework for mediation that we have with the convention at the top, and the model law, and the rules and the notes, and all the different elements that mirror now completely what you have in the area of arbitration. And we have a detailed paper that is out now on strengthening access to mediation. And what we have seen when it has been discussed was that very few countries were actually keen on suggesting mandatory mediation, because I suspect, and these were the arguments we heard, because of the special DNA, and I thank Alexis for having flagged that. There is mediation is very different from arbitration, and it is really based on the voluntary participation. So voluntariness and mandatoriness are something that do not necessarily always work very much together. And especially because we are also looking in the reform options at strengthening or improving the cost and the time of these ISDS cases, and putting in place an additional hurdle or an additional procedural step that could end up in a waste of time and a waste of money is really not where the working group is going so far. But what we've seen is really important is to be more conducive during this cooling off period that is sometimes too short, and most of the cases not conducive for government officials to engage in a mediation procedure, because the only thing you have is cool off for 3 months, and then then you go to arbitration. So it's difficult for government officials to make the case with their for example, with their minister that, okay, why don't we give it a try to a mediation if the treaty doesn't provide for it? So this is definitely something that is part of the paper that has been prepared and will be discussed in an intersessional meeting in Hong Kong in November. And again, at the next working group session in February, which is strengthening the offer for mediation in the context of the ISDS reform. And I'm very grateful to Alexi also for having flagged the issue of transparency. And this is something that we will definitely have to look into in order to make sure that the advances that are sort of the cornerstone of the reform of ISDS that we are witnessing and working on in UNCITRAL currently is not undermined by putting out something which goes back to good old confidentiality, which we've seen doesn't work very well in the context of investment disputes. So that's what I wanted to say briefly. I hope I haven't taken too much time, and of course happy to exchange and discuss with all of you. Thank you.
Thank you very much, Anna. This has been terrific to hear this presentation from you, not on behalf of the institution, as you mentioned it, but your own thoughts, and that's very enlightening. I have one question for you before we open the discussion with the panel, and it's the following. I have had the great privilege to observe the discussions within Working Group 3 over the last years. And one experience that I think is something to follow from other regions is how the European Union countries have been able to have one voice through the European Commission within the discussions in UNCITRAL, even though we all know that sometimes they have their own issues to resolve within their own countries before they go to the meetings with one voice. And they have 27, maybe now 26 countries represented during the Working Group 3 discussions with their own voice. But at the end, somehow, at least my reading of this is that the EC is the voice for all this block of countries. Do you think this experience could be of help, for example, for the region in Latin America, to be able to construct something on which you have, I don't know, 15, 16, 17 countries represented within the working group, but one voice as an institutional position that represents the bloc for these discussions? Do you think that's something that should be explored?
Well, thanks very much. I think you've used exactly the word that is not adapted to the Latin American context, and which is very much the case in the EU. It's institutional, because there is no representing institution, as is the case in the EU, that has in its mandate to propose, to negotiate these free trade agreements and to propose solutions or reform to ISDS. And I would like to say in this context that Working Group 3 is the only one in UNCITRAL where the EU has the front seat and the member states have the second in the second row. In other working groups, that's not the case. You know, usually it's the EU sits in the back and the member states are the ones taking the floor. So I think it would be at the stage where we are currently, it would be actually a pity to have only one voice for Latin America, because there has been so much experience. I mean, the last 15 years, as painful as they have been, have made you really very proficient in these different aspects of promotion, prevention, negotiating appropriate treaties, etc. And you've all done this in with your own DNA. So I think the more we can hear from the different countries in how they see the reform and how it resonates with them, the more beneficial it's going to be for the group. I think the working group would be deprived of all this diversity if we had only one voice for Latin America. But I agree with you sometimes, you know, and sometimes it's also a matter of making sure that the voices are heard to begin with, and that countries actually take the floor, because that's where I'm a bit on mission here to say we want to hear more from you guys.
Thank you, Anna. Very well. I invite my panelists to make some final comments, and we may go in the same order if you will. Ana Maria, if you have any comments on what you have heard from Alexi, Anna, or anything else that you want to mention, please.
Thank you, Alvaro. I just want to comment on Anna's last intervention and to reaffirm, I think you know that for Colombia, the participation in these multilateral scenarios where these issues are being discussed is very important, precisely because it's a great opportunity to share experience and also to share concerns and to try and find a solution. I must say that all the information and the knowledge that is shared by states in those scenarios has been very useful for Colombia in order to build and create the management, prevention, and handling of negotiation first stages of disputes. So we do value a lot and take very serious our participation in these scenarios.
Thank you very much, Ana Maria. Alexi?
Well, it seems to me that there is broad consensus to welcome mediation in the context of ISDS. I think that has been reflected by the various presentations. As far as mandatory mediation, there's much more skepticism, and I think that Anna said it rightly when she highlighted the contrast between the inherent voluntary nature of mediation, wanting to sit down and wanting to agree. That's a big difference with arbitration, where you will have a reward and you may not like the outcome, but this would be an award. In mediation, there is a favorable outcome only if the parties agree to it. So there is a tension between that inherent voluntary nature and the idea of compulsory mediation. I think that tension exists in commercial arbitration. We see that from experience. But it will exist even more in the context of ISDS.
Thank you, Alexi. And if I may comment on something that comes to mind at this point, from my own experience, and I think this is why the UNCITRAL work is so important on this field, is that one of the elements, from my point of view, that has discouraged mediation in general in investor-state dispute settlement is how the ICSID convention was framed in its origin in terms of the recommendations issued by the Conciliation Commission under the ICSID convention. And this goes directly to the point Alexi made during this presentation on the enforcement of the mediation agreements. And we now have the Singapore Convention, which is a very good example on how to treat these problems that we have within the system. As long as the ICSID Convention keeps us just a recommendation that is not binding to the parties at the end as a result of the recommendation by the Conciliation Commission, I think there is little incentive both for states and investors to engage on serious discussions within the framework of the ICSID Convention to try to reach settlement under the rules for the Conciliation Commission as they are framed. And we all know the difficulties that we have to amend the ICSID Convention. I think ICSID has made a great effort through the amendment of the rules to try to solve these issues. But there is a point on which I think we have to point attention in the future within the work of the UNCITRAL working group. Anna, please, your closing words.
Thank you very much. Yes, thanks very much for bringing to everybody's attention something that I had also in my mind, which is the ICSID rules amendment. And in this rules amendment, there is a special set of rules that the Secretariat, the ICSID Secretariat has prepared on investor-state mediation. So this is, I would say, one more tool in the ICSID toolbox that ICSID is putting forward as part of their amendments. And how this is now taken on board in the working group is that the working group said we should not focus our reform efforts on developing another set of rules. There are generic rules such as the UNCITRAL mediation rules. There are specific rules. Alexis mentioned the IBA, but we also have now the ICSID mediation rules. So in terms of the reform, there's no need to spend time on developing yet another set of rules, but rather we are going to concentrate on, through the delivery mechanism of the reform, which is going to be a multilateral convention, which will include all of these reform elements and make them applicable to existing treaties and to future treaties. What we're going to do is to strengthen access to mediation, make the treaty language more conducive to allow a mediation, make sure that the timeframes for mediation are more adequate, make sure also that mediation in the ISDS context keeps a degree of transparency that, again, Alexis mentioned before. So just to make sure that mediation is not reinventing the wheel, not reinventing mediation rules or mediation practice, using what is there and making sure that this can be used effectively in the ISDS context, because there is a call for it on the part of the states, definitely. Although some would say, of course, the states say we want more mediation, but when it comes to mediating, nobody is there. But in fact, in reality, there are more and more, as Alexis was mentioning, there are more and more of these experiences of actual successful negotiation of disputes or settlement of disputes that at the end of the day contribute to what we are all engaged in, which is making sure that investment comes into the countries and stays and not leaves because they're disgruntled or unhappy about the way their disputes are being handled.
Thank you very much, Anna. And with this, we come to the end of panel 3. I want to thank you for such a lively discussion and for such great presentations by the three of you. Thank you very much. Now we go to the final phase of this event. Invite now Professor Makane to enlighten us with a final presentation that we have the easy task of trying to tell us what we should come out with after these 3 panels that we have had this morning, afternoon, evening, wherever you are located in the world. I would like to mention that Professor Makane Moise-Mabenge is Professor of International Law at the Faculty of Law of the University of Geneva and Director of the Department of International Law and International Organization. He is an affiliate professor at Sciences Po Paris School of Law. He is the president of the African Society of International Law and a member of the Curatorium of the Hague Academy of International Law. He acts as counsel in disputes before international courts and tribunals, before the International Court of Justice, of course, and in investment cases, and as arbitrator and as advisor for governments. He is involved in the negotiations of several international investment agreements in Africa, and he is the author of several publications in the field of international law. And this is why we have thought, all the organizers of this event, that bringing Professor Makane to this event to share with us final comments and his experience from the African point of view will be of great value for the Latin American region. Professor Makane, thank you very much.
Thank you so much, Alvaro, for the kind introduction. Many thanks to Carola and Credimi for the invitation, and in particular to Alvaro and well, Alvaro number 2 and Pascal for the invitation. It is a pleasure to be here and to share a bit of the African experience. I would like to congratulate very much the organizers for putting in place such a exciting program, and I would like, of course, also to congratulate warmly the distinguished speakers and moderators for the very stimulating discussions that we have been having since the beginning of this conference. Allow me, maybe, Alvaro, just to start by saying that Latin America has been quite often a source of alert for the African continent or the African countries when it comes to the investment regime, and in particular when it comes to investment arbitration. It is because of the experience of Latin American countries with the investment arbitration system that many African countries actually started to pay attention to investment arbitration. When we recall what has been happening in the early 2000s, in particular with Argentina, that was a wake-up call. That was a wake-up call for many African countries when they saw actually a country like Argentina, but as a Latin American countries facing ISDS, facing the investment arbitration. This is what has prompted some of them to start questioning and start thinking about how they should position themselves vis-a-vis the investment arbitration system. And even more recently, it is again because of the experience of a Latin American country that the African Union last year adopted a declaration, the only declaration that has been adopted in the world on the risk of ISDS deriving from COVID-related measures. One of the reasons why the African Union member states decided to adopt such a declaration is because of one investment case that has been initiated in May 2020 against Peru. And that investment case was actually deriving from some of the measures that Peru has adopted to handle and manage the COVID-19 pandemic. And this was another wake-up call for African countries to actually start thinking about how they could mitigate the risk of ISDS that can derive from COVID-19 related measures, and how they could protect themselves from the risk of investment arbitration. So this is why I always like to say that Latin American countries are quite often a source of alert for Africa. But does it mean that we can speak in terms of total convergences between Latin America and Africa when it comes to the investment regime in general, and when it comes to investment arbitration in particular? I don't think so. I don't think that we can neither speak in terms of total convergences nor in terms of total divergences. when it comes to the interrelationship between Latin America and Africa within the investment regime. I think that when we pay attention to that relationship between Latin America and Africa within the investment regime, we should actually speak more in terms of semi-divergences and semi-convergences. Let me start with what I call the semi-divergences. You know, when you look at the premise of investment regulation in Latin America and the premise of investment regulation in Africa are actually different. In Latin America, my perception is that investment regulation is still very much based on national sovereignty approaches. You still have every single Latin American country with its own approach to investment regulation. So domestic investment policies, domestic approaches to investment policies are still very important in the Latin American context. When you take into account Africa, investment regulation in Africa is very much based on regional and continental integration processes. And I think this is one of the major differences, that investment regulation in Africa is very much based on regional and continental integration processes, while investment regulation in Latin America relies more often on national sovereignty approaches. As many of you know, in Africa, we have 8 regional economic communities. We have the Arab Maghreb Union, we have the Community of Sahel-Saharan States, we have the Common Market of Eastern and Southern Africa, we have the East African Community, we have the Community of West African States, we have also the Economic Community of Central African States, we have in the Horn of Africa the IGAD, the Intergovernmental Authority for Development, and in the very southern part of Africa, we have another regional economic community that is quite often known in our circles, the SADC, the Southern African Development Community. So we have these 8 regional economic communities, and almost each of those regional economic communities intervene in investment regulation. They adopt regional instruments that would actually regulate investment flows on the African continent. And on top now, today, on top of these regional economic communities, you have this process of continentalization of investment regulation, because now, since 2012, the African Union, which is the continental organization composed of 55 member states, is actually also engaged in investment regulation. So what does it mean? It means that African countries have more difficulties than Latin American countries to escape certain trends in investment regulation. I would say that in Latin America, we face more some sort of regulatory fragmentation when it comes to the investment regime, while in Africa, what we are witnessing is to a certain extent regulatory cross-fertilization, where because of the action of all these regional economic communities and the African Union, rules and principles, new trends in investment lawmaking are cross-fertilizing everywhere on the continent, without sometimes some of these governments being very much, how do you say that, supportive of those trends, but the integration process is at such a level that cross-fertilization happens de facto on the continent. But the reason why I prefer to qualify this divergence between Latin America and Africa as a semi-divergence, it's because at the end of the day, when you really look at what is going on, at the reality, I think we can realize that there's a common denominator. There is, to a certain extent, a common denominator between Latin America and Africa, and that common denominator is that in both contexts, it has appeared that integrating investment policies is a very risky task, is a very risky project. It is even sometimes a very risky project for integration itself. When we think about Latin America, we have at least one rare example of integration or of attempt to integrate investment policies that has not worked. Mercosur. Mercosur is, I think, at its third attempt to have a Mercosur investment protocol. In 2017, Mercosur adopted the Mercosur protocol on investment cooperation and facilitation. That was the third attempt, because in 1994, there were already two investment protocols, the Colonia Protocol that was supposed to regulate Mercosur investors, and the Buenos Aires Protocol of 1994 that was supposed to regulate non-Mercosur investors. None of those investment instruments never entered into force. They never entered into force. So it's interesting to see that one of the rare examples of integration of investment policies that we have in Latin America has still not worked at the present time. And it is the same in Africa. It is the same. Yes, we have this process of integration. We have a very massive process of integration of investment policies. But when you pay attention, in many cases, those processes are either based on soft law. So if you take, for instance, SADC, they have a model. They have a model bilateral investment treaty template. This is what they call integration. If you take East African Community, they have a model for the East African Community. So they would go for more soft law approach than hard law approaches. And those regional economic communities which went for more hard law approaches, for more binding approaches, well, they kind of failed. You know, COMESA, for instance, the Common Market of Eastern and Southern Africa, they had an investment treaty in 2007. That investment treaty for COMESA never entered into force. And in 2017, they had to revise it. Now we are still waiting. We are in 2021. We are still waiting to see whether this investment treaty for COMESA will enter into force. One exception of success in integrating investment policies based on a binding legal approach is ECOWAS. ECOWAS, the Economic Community of West African States, is the only region that has kind of been successful in really adopting a binding approach to the integration of investment policies. But even at the continental level, I think that many of the colleagues here have heard about the Pan-African Investment Code. The Pan-African Investment Code is another example of failure in integrating at the continental level investment rules and investment policies. The idea behind the Pan-African Investment Code was to have a binding treaty that would be subject to ratification. And at the end, it didn't work, and it was just adopted as a continental model within the African Union. And what these processes of integration of investment policies show is that integrating investment arbitration is even more risky. Finding a common position on investment arbitration is even more risky. I was mentioning how we failed with the Pan-African Investment Code. What undermined the Pan-African Investment Code is the lack of consensus among African countries on how to deal with investment arbitration. This is the reason why it didn't work. So we have this signal. We have this signal today in Africa. We are going to negotiate very soon. We have already started actually to negotiate the investment protocol to the African Continental Free Trade Area. Since January 2021, a continental free trade area has been put in place on the continent. And the second phase in the building of that African Continental Free Trade Area is to negotiate an investment protocol. And I can tell you that building a common position on investment arbitration might be once again a huge challenge that might destroy an integration process on the continent. So what does it mean? It means, and I was very interested to hear the colleagues here insisting on dispute prevention. You have more and more voices in Africa that are maybe calling for dispute prevention, mediation, alternative means of dispute settlement. I've been even hearing in some of the negotiations, some member states insisting on the word de-escalation. They wanted to make sure that we distinguish between dispute prevention and dispute de-escalation. And so there is some calls, some voices among the African countries that are calling for going beyond investment arbitration. But at the same time, you have also many of those states that are attached to investment arbitration. We've been hearing, last week we had a meeting where we were discussing some of the scope of the negotiations of the future investment protocol. And some countries, some member states of the African Union were saying that they are scared of discrimination, that it wouldn't be normal that African investors in the context of the investment protocol to the AFCFTA do not have access to investment arbitration, while non-African investors, because of bilateral investment treaties and as investment agreements that African countries have concluded, would have access to investment arbitration. So there is also many concerns of not discriminating, not giving less protection to African investors in the context of the African investment protocol than the protection we are giving to non-African investors. So this is what I wanted to say about the semi-divergence. Let me now come to what I was calling the semi-convergences. And there I would like to emphasize briefly two levels of semi-convergences. The first level of convergence that I think we can identify between African countries and Latin America is what I would call the culture of investment law. You know, historically, we tend to forget that, but African countries and Latin American countries, they joined forces in the battle for the new international economic order in the 1960s and 1970s. They joined forces for the battle regarding the new international economic order. And one major aspect of that battle for the new international economic order was to reject certain investment standards like the Hull formula. It was also to reject to a certain extent international investment arbitration. And if we check, for instance, one of the resolution that has been adopted during that battle, the Charter on Economic Rights and Duties of States, it was calling for settling disputes regarding expropriation before the domestic courts of states. So there has been these convergences between Latin American countries and African countries in terms of the culture, how they would perceive the culture of investment law and rejecting it. But why do I speak once again in terms of semi-convergences at this level of the investment law culture? Well, I speak in terms of convergences because there has been at the same time some paradoxes. One of the historical paradoxes is while Africa and Latin America were fighting for the new international economic order, this did not prevent at that time African countries to support massively the ICSID Convention. The ICSID Convention entered into force mostly thanks to the support of African countries. So Latin American countries, many of the Latin American countries have been more suspicious of ICSID, of international investment arbitration, while African countries at that time where they were joining force, still there was this paradox that they joined. This is what I would call an historical paradox. But even when we look today we still see the paradox. At a time when Latin American countries, many of them have abandoned some of the Latin American doctrines, what we are seeing is that Africa has become a very fertile ground for some of the Latin American doctrines. You know, I always like to say that Africa has resurrected Calvo. Alvaro was speaking in his introduction about the Calvo doctrine? Well, you have many African countries today that have resurrected Calvo. Think about the South African 2015 South African investment legislation that is rejecting any possibility for ISDS and just disputes being solved before domestic courts. Think about the 2017 Tanzanian Act on Permanent Sovereignty over Natural Resources, which is also rejecting the idea of international investment arbitration. And I could go on and on with examples, but this is why we cannot talk about a total convergence when it comes to the culture of investment law, because today, while many Latin American countries have taken distance towards some of those doctrines are resurrected in Africa. Second level of convergence, of semi-convergence, is with respect to the reform, with respect to the reform of the investment regime. I think that when we look at the reform of the investment regime, we can see that, of course, there are convergences. A lot of the speakers today have spoken a lot, have spoken mainly about the right to regulate, about the need for balanced investment agreements, even balanced investment arbitration. I think that at that level, there's no need to insist. There are convergences. But why I prefer to speak again in terms of semi-convergences is because, in my view, I think that African countries are going further. They are going further than Latin American countries in how they perceive the reform of the investment regime. The notion of investment in Africa is very much linked to the Salini test. It's also no longer asset-based, but enterprise-based. When you look at some of the investment standards, there is total rejection of some of the traditional investment standards by contrast to Latin America. FET, most African countries are no longer interested in seeing FET. They have reinvented new principles like FAT, for administrative treatment, administrative and judicial treatment. They simply no longer want to see something called FET, investors' obligations. There was this very exciting discussion today about responsible investment. The vision on the continent is that investment promotion, facilitation, and protection should target only responsible investment. And for that, the only way to do that is to go for formal, strict investors or obligation. But even ISDS, what we are witnessing by contrast to Latin America on the African continent, is that there are more and more limitations, more and more restrictions on how ISDS should happen. Exhaustion of local remedies, reducing the scope of jurisdiction of investment tribunals, etc., etc. So that's why I prefer to speak in terms of semi-convergence when it comes to the reform efforts, because I believe that those reform efforts on the continent in Africa are much more radical than what we are seeing in Latin America, even if Latin American countries have been more victims, but I put it in quotes, of course, more victims of the investment regime than African countries, at least in my view. But this brings me to the conclusion, Alvaro. What I wanted just to be a bit provocative here. Because quite often, when our colleagues from the developed world look at what is going on in Africa or in Latin America, but also many of our colleagues in the developing world, they tend to put all the developing countries in the same basket. They call us the global south. The global south. I was never very convinced by this concept. It's a very nice concept. No? It looks very nice as a concept, but I was never very convinced by this idea of a global south. And in particular, when it comes to the investment regime in general and to investment arbitration, I don't think we can talk about an actor called the global south. You know, of course, there is emulation, of course, there is inspiration between all those countries in the developing world. But when you take the situation of Latin America and the situation of Africa, I don't think we can put all those countries in the same basket call the Global South. What we are witnessing in Africa is an African vision to investment regulation, an African vision to investment arbitration. And some of us have been calling that the Africanization of international investment law. I don't know if there is something we can call the Latin Americanization of investment law. I doubt. I really doubt that we can talk about it, but no matter the limits or the struggles, I think that one reality is that today in Africa, there is a process of Africanization that is taking inspiration from Europe, that is taking inspiration from Asia, that is of course taking inspiration from Latin America, because for instance, if you think about the treaties that have been negotiated by Brazil with some African countries, of course, there is necessarily some sort of influence. But I think there is an autonomous approach to investment law and to investment arbitration that we are witnessing, and this is what we call Africanization. But for sure, Africanization has benefited a lot from the experience and I would say the behavior, the position that traditionally Latin American countries have taken vis-a-vis the investment regime. I think that Latin American countries have inspired us to believe that we can also be rule makers in the system and not just some rule takers and rule consumers. So because of that, I think that Africa owes a lot to Latin America. And once again, thank you very much for the invitation. And I hope that we can have more often this type of interactions where we can actually discuss our experiences from various continents, because the regime of the reform of the investment regime really needs cross-fertilization and inspiration in terms of best practices. Thank you very much.
Thank you, Professor Makane. This has been great to hear from you the African experience and what you call the cross-fertilization with the Latin American experience. And I think this has been a learning experience for everyone who has been able to listen to these remarks. And before I pass the floor to Pascal, I would like to ask you a question. You may remember that we had a discussion more than a year ago, and I did all my efforts. I tried very hard to pull out your tongue on one particular discussion that the African Union was having at that time when we all came to the lockdown as a consequence of the COVID pandemic. What has happened with that particular effort? I understand there was a declaration, and maybe you can comment a little bit on that.
Yes, thank you very much, Alvaro. Well, you remember that I promised that I would circulate the declaration once it would be adopted, and I did so. I sent it to Pascal and Julia, and I hope that they shared the declaration with you. Well, the African Union adopted the declaration in December 2020 after a lot of meetings and struggles on the content of that declaration regarding the risk of ISDS deriving from COVID-19 measures. But I'm very happy that you are asking me about this declaration, because I think this declaration, to a certain extent, shows how complicated it is, how complex it is today to actually build a common African position when it comes to ISDS, when it comes to investment arbitration. Because if you remember the discussion we had a year ago, I told you that initially the draft declaration was calling for a suspension of ISDS. Suspension of ISDS till the end of the pandemic. So we don't know when the pandemic is going to end, but that was the idea, suspension of ISDS. ISDS, of course, based on intra-African investment agreements, bilateral investment treaties, because African countries wouldn't be able to suspend ISDS with countries concluded with non-African countries. So that was the call suspension of ISDS, and it didn't work. It didn't work because you had many countries that said no. We don't want to open the Pandora box for unilateral actions when it comes to ISDS on the continent, and you had countries that again were very concerned with discriminating African investors. I can't say which ones because of confidentiality reason, but some of the countries have been saying it is not tolerable that African investors do not have access to investment arbitration, while non-African investors can have access to arbitration against African countries. So the consensus at the end was to get rid of this language regarding suspension, and then we focus on mitigating. And this is where this idea of mitigation is also interesting, because mitigation calls for other dispute settlement, as a means of dispute settlement, and like mediation, like conciliation. So many of the countries during the discussion, for instance, were interested in, whether ICSID has developed rules regarding conciliation, regarding mediation, that countries could use to de-escalate or prevent disputes with investors due to their management or handling of COVID-19 measures. So it was very interesting to see that there was some appetite. There was some appetite from those countries for some more, alternative means of dispute settlement. But there was still this idea that in investment disputes should be settled, that investors should be given a chance to have their dispute being settled, and not just a simple suspension of investment arbitration. So I think this shows again the struggles. I've been reading, and I'm not going to say where out of courtesy for some of the colleagues who write these things, but I've been reading in some blogs, people saying that there is a common position of African countries on how to reform ISDS, and because we had a meeting in 2019 in Guinea-Conakry, the first meeting organized by UNCITRAL, by the way, in Africa. But no, there's no common position. That's not true. Out of the 55 countries, only 20 of them, by the way, were in the room. So not even half of the countries were in the room, and they did not agree on a common position. So I'm very happy to see that people still dream about the Pan-African vision to investment arbitration, but it is not there. What is the common position is the idea that we want to Africanize ISDS. This is common position, that we want ISDS to take place in Africa. We want more involvement of Africans in ISDS. We want some of the universal centers like ICSID, why not, to have centers in Africa. So this is where you have a common position, the Africanization. But then how all the ISDS is going to take place, how it's going to be conducted in the future, you have many different positions on the table.
Thank you very much, Professor. This has been very enlightening, and the experience of the African states, of course, it's something that we should follow closely from the Latin American region, with the object in mind of learning from that experience and trying to adopt some practices that can be useful for the discussion within the Latin American countries. Now, I would like to give the floor to Dr. Pascal Akui for the final remarks before the closing of this event. Thank you very much.
Thank you, Alvaro. I would like to thank so much Makan for this wonderful, as usual, and brilliant presentation, and the importance of having someone from inside who will tell the real story, and not someone from outside who, tells things that are not true. Thank you so much, Makan. Having you on this panel is so important for us. And thank you for giving us enough time. And this, I took notes, and I think that it would be very useful to have it, in an article that would be useful for all the generations all over the world. And really, I'm talking from the bottom of my heart. And thank you also for, your presentation builds bridges between continents and reveals how Africa and Latin America are precursor and source of inspiration of each other. And I hope that other continents of the world will have this approach, this humble approach of, being inspired by each other with the specification of everyone, of course. So thank you again, Makan. Before closing the webinar, I would also like to stress the importance of a wonderful cooperation, not only between continents, but also between two research centers, CREDIMI and Carola. It has been stated all along this wonderful webinar. And bringing together efforts to achieve the goal of selecting brilliant speakers on this very important issue. And as shown in this webinar, also allows us to share different points of view, gives the audience the opportunity to approach the problems from several angles and to better understand the subject, and ultimately to raise new questions that the audience can confront with the reality of the practice. And this is also what has been shown by Professor Makan in his presentation. Our thanks go to all the speakers from coming to share their thoughts, to the audience for being so numerous, and to the communication team, thanks to which this webinar was organized and held in optimal conditions. Have an enjoyable end of the day and stay safe, and hope to see you, one day in presence in some part of the world. Thank you again.